Good morning. Good morning. It's Tuesday. We have lots of law to talk about. It's August 6th. I'm unwell. I can't believe it's August. But today we have so much to talk about because honestly, just a lot is happening in the law and it's not a surprise. The fall can be really busy and it runs right up to November, and then everything seems to come screeching to a halt until like January. So this month is going to be busy. Next month is going to be busy, and then we'll start seeing most courts tapering off into the winter holiday season. But as I said, things are busy in the law. So welcome, law nerds. Good to see you. Today, we have a new motion, a new supplement of another supplement from Karen Reed's defense team. I went over the Commonwealth's response in the Karen Reed fight about what the jurors have said in short form content, but I haven't covered it here. So we're going to cover it here too. The judge in New Mexico has all of the smoke in their formal written order on the dismissal of Baldwin's case. I thought that might be interesting to go over together. And of course, the prosecution has now responded in the fight over a new trial for Hannah Gutierrez. So we've got Karen Reed, we've got Hannah Gutierrez Reed. We have a quick update on the Logan Paul Coffeezilla of it all. A lot of you are really interested in that case. It's August. I am exhausted from working the county fair last night as a ticket individual because, well, being a band parent is an additional full-time job and it's one of the things that we get to do. But it's always nice to see the community. But standing in 90-degree heat with a much higher heat index for hours and hours on end is always an adventure. And it reminds me again how old I am. So we are going to talk about all of those things. We'll talk a little bit about back to school, but how was the fair for all of you asking? It's fun. We'll talk about that in a minute. We're going to roll the intro. We'll chat for a moment and then we'll get into the Coffeezilla response. Then we'll get into Karen Reed. The Rust stuff's going to take a little longer because everybody's loquacious at the moment. So we'll get into that towards the end. Of course, replay crew, love you. All of that will be time-stamped down below. And then we'll get to Q&A. I'm sure you've got lots of it. I can't believe it's like fall, because it's not fucking fall. It is a sauna outside, but I can't believe it's actually like fall season with back to school. The back to school traffic. Oh, back to school traffic. And the thing about back to school traffic, our schools are not, where I live, not walkable. They used to be in California. Our schools were very walkable. Kids would, ride their bikes and what have you. Our schools are not walkable. Look, I wanted to live where there's more space. More space often means not walkable. But the back to school year season also brings brand new drivers. So my patience before I'm caffeinated has also been tested today. So I'm like, deep breaths, everybody, deep breaths. It's fall. It's fantastic. I've got a few stories about that for you too. So we should just roll it and then we'll get to the law stuff. It's good to see everybody. And I know a lot of you are still watching all of the Olympics. No spoilers. I'm still behind. And no, I haven't gotten to watch Real Housewives of New Jersey yet. Yes, I mean to. I'm going to have to binge watch it at some point because I am so far behind. But we've got lots of law to catch up on. So that's what we're catching up on today.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not... Let's get into it.
So this year for back to school, my oldest is a junior year of high school here in the States. I don't know how it is elsewhere, but junior year is like a year of existential crisis, right? It is the year where it feels like you have to decide your entire life, which is a whole lot to put on a 16-year-old. My parenting philosophy is like, leave all the options open that you can, and then give yourself a room to keep making decisions, because the decisions you make now, unfortunately, the negative ones can have impact. But if you try to leave doors open, you have a little bit more room to just keep making decisions. And my philosophy in all things in life is we make the best decisions we can with the information that we have at the time. So unfortunately, for all of my neurospicy friends, you know that sometimes like a decision you made when you were 7 still like pops into your brain at night and you're like, rude. Why? Stop. It's so hard. But we really try to lean into, you make the best decision you can at the time with the info you have. When the info changes, sometimes the decision changes, and that's okay. We're humans. But going into junior year, it feels like there is so much pressure. And then my child is somewhat more introverted and guarded. He is not overly loquacious unless he is comfortable with you, which I respect. I am just like, oh my God, we just met. Hey, entire life story, which oftentimes is just way too much. So we're opposite ends of the spectrum on that. But he started English. He had a ton of homework over the summer first for his classes. He has it. Junior year is so much, but he has a lot of schoolwork. It started with a book that he did not love. When we were talking about the book he needed to read for English, he's like, there's no character development. This book is lazy and it just leans into buzzwords. And some of those buzzwords are used in like different context in different ways. And I don't know if the author means what they think that means. And instead of like developing a plot line or a story, they just like lean into like, I don't know, sensationalism and buzzwords. And he's like, I just hate it. And I'm like, buddy, I get it. He's like, everything in this book feels like a headline. I'm not going to name the book just because he hated it so much, but everything in the book feels like a news headline. Like it's just develop the story. Just like, where's the rest of the story? So he was frustrated by that. So then they get to English. And they have to do a presentation on Friday. And the presentation that they have to do on Friday is all about them. But you have to follow a prompt. And the prompt that you have to finish for your class presentation with your peers junior year, which already is an existential crisis because somehow they want 16-year-olds to be like, pick your college, plan your this, blah, blah, blah. Is what's important about you. Not what's important to you, not what's a hobby that you enjoy that people might not know what you know, not a fun fact about yourself, not a what are you looking forward to this year? No. What's important about you? So my lovely 16-year-old is like, this is an existential crisis. What is important about me? Is there anything outside my hobbies that is important? Like, who am I? And I'm like, oh my God, it is the first day. I can't. What is important about you? I'm like, buddy, go with what's important to you. Share something that you like. Share something that you like that you're comfortable sharing with your peers. So something that's not like a deep core part of your identity. Because again, junior year, you can't just ask people. I mean, maybe some kids are that confident, maybe they're not. But to ask a kid to stand up in front of a class of kids that you don't know their history with, to stand up in front of their classmates and be like, this is a core fundamental part of my identity. Have you met 16-year-olds? Lord, I'm like, hey, buddy, let's talk about cooking. You really enjoy cooking. It is important to you. I think it's important that everybody knows that you make a good meal. You never know. You might make some new friends because they're like, oh, that sounds delightful. Can you just talk about ramen? Like I stand behind you. Whatever grade you get, what's important about you, ramen. Just go with it. I'm here. I support you. I've got you. But the amount of anxiousness the what's important about you has caused in literally a day. I'm like, go with a hobby. Like, go with a hobby. I got your back on this. I have absolutely got your back. Because trying to, like, as your identity is still developing, what's important about you. Oh, Lord. I'm like, your peers don't cook nearly as well as you do. Just lean in. lean in, or go a completely humorous route and do like a literary analysis of a meme that you think represents you. I'm like, I think that would be cheeky. Why not? So it's only Tuesday, you guys. I ready. I am not ready. I am not ready. I just not at all. But I was like, hey buddy, I got your back. I got your back. Whatever. It's a prompt I don't agree with either. It would have been so nice to be like, what's a hobby people don't know about you? Because you know what? Who knows? Maybe there's a soccer kid who's crocheting in the stands, just like Tom Daley in the Olympics. You never know. Maybe somebody has a, whatever. So I'm like, I got you. I also hate this prompt. It feels so challenging. Oh, I love the suggestion. Eloy says, think marketing. This is a branding challenge. I love it. I'm going to rephrase this challenge to him. Buddy, how do you brand yourself? Knitting. I'm sorry. I keep saying crocheting. Nishay, thank you. To all of the crafters in the chat, my deepest apologies. I'll go grab a gray hoodie in a minute. My deepest apologies for continuing to conflate crocheting and knitting. I use them synonymously. I shouldn't. My deepest apologies. Deepest apologies. Truly, I cannot keep them separate in my brain. Probably because I can't do either. But like, why is this year coming in so hot? My kid is like, can I just go back to chemistry where things are like known? I'm like, yes. Go back to chemistry. He loves chemistry. So excited about chemistry. But the rest of this, he's like, miss me. But we had a really nice time at the fair, ran into lots of lovely members of our community. It was very, very busy. What I will say is our high school band gets to work ticketing, which I enjoy. You get to be chatty. You get to see how people are doing. You get to run into everybody because everyone comes through the gates. So you get a little, hi, how are you? I enjoy it. My kid's actually really good at like traffic and line management. He sees it as one of those games where you have to, one of those mind puzzle games where you have to like manage like ingredients or whatever coming down a road and you have to do all of that. Perfect. So he was doing really well at traffic mitigation yesterday. One of the other high school bands has to work the parking lots. Not only are they dusty, but there is no shade. We have shade and fans, and then inside the ticket booths are air conditioned. But I don't know how that band ended up with the parking lots, but ooh boy, with the parking lots, I'm real thankful. It was hot as hell and it was a long night, but I'm real thankful. And the Tennessee of it all, and and I promise we'll move on from the county fair in a minute. They went back to shooting somebody out of the cannon once a night. So I actually got to watch the cannon shoot, or whatever you would refer to it as. I'll post a video that I got of it on social later, but they actually shoot a person out of a cannon. It was fairly impressive. Like, I haven't seen a human hurled out of a cannon in a really long time. Like, what in the 1980s is happening with like all the daredeviling? But they launch a human out of a cannon. That was entertaining. And then because it is Middle Tennessee, let me tell you what the itinerary is for the fair. I texted this to friends over the week, and they were like, oh, those of you that are going to laugh in Southern, I get it. But for those of you who do not do county fairs the way the South does county fairs, this is newer to me. Our local fair was like, the lifeguards have a fish taco booth and you can go buy art and other goods. It was more of a craft fair than like a proper county fair. County fair, here we go. County fair. Opening night was the 4-H shows. First of all, the 4-H kids, and they're especially the ones who have the giant like celebratory belt buckles are incredible. Like, it's incredible. It's a whole thing and I love it. So the giant belt buckles for winning whatever competition they win, and the kids that are coming in to show, fantastic. I love it. I think it's amazing. So that was Friday. Saturday is the beef show and the 4-H cake auction. Sunday was the dairy goat show, the biscuit competition, and the Goo Goo Cluster celebration, because Tennessee. Monday was the steer show, not to be confused, by the way, with Saturday's beef show. The beef show and the steer show are different. Don't ask me how. I can't tell you. but that's my goal. I'm going to find out how the beef show and the steer show are different. Tuesday is the goat show, not to be confused with the dairy goat show. Wednesday, dairy cattle. Thursday this week is going to be the 4-H parade and sale. Yes, sale. And then Saturday is the sheep and lamb show. So all of that is what's going on with all of the things. So all the things are happening. The chat knows the difference. Chat, you're great. I learned things. Thank you. It's a whole thing. But so yeah, county fair. And it was kind of fun to see, you know, to take a backseat to the teens being teens. Our local fair when I was growing up, again, more like a craft fair, game booths, no rides that were built in the middle of the night. But our fair, we only had one high school where I grew up. So it was a fairly small local fair. Our county here has a multitude of high schools. So the teenageness of going to the fair and interacting with the kids from other schools, and they all interact with each other through sports and band and all the rest of their activities, but it's hilarious to watch. It's, the teenageriness. So yesterday was also the first day of school and the fair. It was a delight. Hot, but a delight to witness. It's just so fun. It's just so fun. I'm so glad it's not me. Meanwhile, my kid's like, how are you going to just ask me to stand up in front of a class full of people and tell you what's important about me? And I'm really appreciative of my teen for not saying like, D's nuts and sitting back down at this point. So, back to school. Yay. You know, who's not worried about back to school is everybody else that we're going to talk about today. I don't think so. That's fantastic. You know, I'm excited. Let's talk about Coffeezilla first real quick, because it's going to be brief. I know we covered it last time and we are going to cover it again. This is kind of our quick bits for the day. Are we going to roll the quick bits bumper because I never get to anymore? Yeah, this is our quick bit for the day. Is it just the one? Yeah, it is a quick bit instead of quick bits, but you get the point. Quick bits. Like same, quick bit, quick bits. So for those of you following this story, Logan Paul has sued YouTube creator Coffeezilla. Coffeezilla did an expose, if you will, breaking down Logan Paul's crypto project, Crypto Zoo, which was meant to be a crypto game, but you earned money, but it was like Pokemon, but there was a, like, I don't know, like dragon egg breeding part of it. And then those rare eggs were supposed to give you more money if you bred them with other rare eggs, and you were supposed to come up with these, you know, different types of animals. And the whole thing seemed like just a complete bust, but lots of people were excited about it. Logan Paul has a massive audience that are excited about him, his products, and the things that he creates. So the people that were interviewed by Coffeezilla lost, some of them, you know, lots, hundreds of thousands of dollars, if not thousands of dollars. And Logan Paul was like, it's not supposed to be an investment token, but the game never worked the way it was supposed to. And we saw some of the pictures of the animals that were supposed to be bred through the game that never worked properly. Wild. So Logan Paul turned around and flamed out on Coffeezilla on the internet, and Coffeezilla did what content creators do and made videos about it. And then Logan Paul apologized and was like, Coffeezilla, you know, you're absolutely right. Thank you. And Coffeezilla, I appreciate you. I broke that all down on the quick bits with the clip of Logan Paul's video. We covered it here in depth. That entire lawsuit was, you know, talking about Logan Paul's charisma and how he never intended for this and that. I drew the parallels to Elizabeth Holmes, who said, I only intended to do good. Yeah, well, the jury found that what you did was, you know, fraud. So your intentions and the actions are different here, and the jury's going to hold you responsible for the actions. So Logan Paul turns around, sues Coffeezilla in federal court in Texas over 2 videos and a tweet. I don't think a ton of this lawsuit, and I tell you guys when I'm neutral on the thing, like I want to see how this plays out, when I'm like, good luck. And when I'm like, okay, this lawsuit must stand. This lawsuit must stand. And that's how I feel about some of the other defamation suits we're covering on this channel. But this one we read and I was like, this is kind of embarrassing. Like it's kind of an embarrassing lawsuit. And it's, Coffeezilla put out a video responding to it. I agree with his perspective that this lawsuit is to try to silence him or intimidate him, but I have additional thoughts on that, in that I think this is how Logan Paul wants to respond to this, to put it out in court and be like, I'm the good guy. I didn't intend it. Because when you tell your story in a lawsuit, nobody's really clipping that down and making reacts videos to it, right? You're not responding in a video. You are putting it in a lawsuit. And then if you don't like the way it's received, a la Tom Sandoval, you can just go, oh, I didn't know that's how my lawyers were going to do it. That's on the lawyers. That's not on me. So there's like low risk, possibly high reward, and you get to see how it runs. So I think there's a massive, massive PR part of this that Coffeezilla didn't address, but I understand that too. So we're going to link his video down below if you want to go support him in this lawsuit. He's fighting with his insurance carrier over whether or not they will be covering this lawsuit. For those of you that followed the Amber Heard insurance lawsuits, you know that these can be extensive fights where carriers are like, yeah, but what's being alleged here is intentional action and we don't cover intentional action, because it's alleged here to be defamation of a public figure, which involves that malice element, malice in the legal sense of the word, not the like mean sense of the word, malice being the knowing disregard for the truth or knowing falsity. So Coffeezilla is fighting with his insurance carrier. He's put out a video sharing how people can support him, and that is going to be linked down below if you choose to go support him. It is important, I think, when creators stand up to stuff like this. We saw Ethan Klein do that and not back down on a lawsuit that not only did he win on, but created actually a really great ruling from the court that you can go to and look at how courts are thinking about what is and is not fair use, especially in the commentary and comedy space. So will we see Coffeezilla have to fight this out that way? Probably, but is it needed? I think so. Oftentimes those with money will try to silence those that they think that they can, because they can ride them out. And when you look at how much lawsuits cost, we just talked about this in the Toddy Westbrook lawsuit. When you look at how much lawsuits cost, it doesn't surprise me when at the end of the day, sometimes people are like, I just have to walk away from this. Like, I just have to walk away from this because I don't know how we're going to bounce back financially from it. But Coffeezilla has a huge community. If any of you are not familiar with his work, you can go check it out. If you watch the videos, if you watch the series again, all of that helps grow the channel. Growing the channel helps support Coffeezilla. He also has merch and a Patreon and things like that. So let us go to his response. I expect we will see more down the road from a motion to dismiss and things like that. But this is the initial response. Remember, a lot of these are going to be boilerplate. We're going to look at it real quick, and then we're going to move on to Karen Reed stuff. But again, I wanted to share it for whatever it helps, sharing what another creator on the platform is going through, especially when this lawsuit is dumb. It's a dumb lawsuit on Logan Paul's behalf. It is not a good lawsuit. Okay, so this is Logan Paul versus Coffeezilla and his companies. This is the response. Now comes Defendant. We're just going to refer to Defendant as Coffee and or Coffeezilla, but Stephen. Generally applicable denials. These are your general denials in a response. General denials. Deny, deny, deny. Nature of the action. Defendants deny the allegations contained in paragraph 1, paragraph 2. Defendant lacks sufficient knowledge. These are all of your specific responses. They go paragraph by paragraph with your general denials. Parties. Defendant doesn't know enough about Logan Paul to say. Jurisdiction and venues. Defendant denies. Defendant denies that. Here's a little shade. Defendants deny the allegation in paragraph 17 of the complaint that the amount in controversy exceeds $75,000, as plaintiff has a global reputation as a serial liar, a tasteless exploiter, and an untrustworthy entrepreneur, and he is incapable of sustaining more than $75,000 in damage to his already sullied reputation. Look, if Logan Paul is going to spend like 49 pages talking about his charisma and what a great guy he is, I'm not surprised. I'm not surprised that we're getting in these general denials just a smattering of shade. But that is a strong statement. We deny that the amount in controversy exceeds $75,000 as plaintiff has a global reputation as a serial liar, tasteless exploiter, and untrustworthy entrepreneur, and he is incapable of sustaining more than $75,000 in damage to his already sullied reputation. Defendants further deny that plaintiff is capable of being damaged from allegations of unfair or improper business dealings, as plaintiff was already infamous for various business ventures which have been widely characterized as unfair and improper. Undefamable, right? Is their statement here. He can't be defamed. And this is part of why Logan Paul is saying that some of this is defamation per se, where you don't have to prove damages. Factual allegations, these are all denials. So we're not going to go through each denial. Again, I think we will probably get more in our next motions that we will see. And I need to ask somebody procedurally why they did the answer before a motion to dismiss. I'm sure it is procedurally the order in which things need to happen for federal court in Texas, but oftentimes we will see that motion to dismiss first and then the answer afterwards. This is the answer. 73, defendants deny the characterization of the video in paragraph 73. The video speaks for itself, and on with the video speaks for itself. And that is the Thank You Coffeezilla video we played the last time I talked about this. That is still up on Logan's channel. But if you want to watch my channel talking about it, it's timestamped in the last video where I cover this. And again, general denials, paragraph by paragraph. So yes, they are going by each paragraph and denying everything. So let's see if there's any more tidbits about Logan Paul's big reputation, or I'm sorry, sullied reputation, as I say. First cause of relief, libel per se. Remember, per se does not require a proof of damages. It's why they are going after Logan, being they. It's why Logan and his attorneys are going after per se, because you don't have to say, hey, this video series hurt my reputation. You can just say this video series accuses me of a crime. Second claim for relief, libel per se. Logan Paul's scam isn't over. I'm waiting for them to be like, also it's not. Also, it's not. Second claim for relief, libel per se. Logan Paul's refund. Video speaks for itself. Also, where's the lie though? Not in here. Defenses. These are more general defenses. This is going to be everything and the kitchen sink that you can put into a response with your defenses. They go on to say plaintiff is a general purpose public figure or alternatively a limited purpose public figure regarding CryptoZoo. I think the complaint well establishes that Logan Paul is a public figure. It's what they spend a lot of the complaint touting, is that he is a, what was it? Worldwide champion in the WWE and such. So there's that. This is going through plaintiff's employees who he said scammed him. Demand for jury, prayer for relief, which is defendant requests the court dismiss the complaint against them without prejudice and award attorney's fees. That's not really what the motion is for, but that's what's going to happen. So this is the response from Coffeezilla's lawyers, which aside from a solid paragraph of shade is what you expect to see in jurisdictions that allow for general denials. Some jurisdictions you need much more detail in a answer, but a lot of jurisdictions, this is it. These are all our potential defenses. These are all the denials, and that's it. But the sentence of shade that was in there, I think, was worthy of discussing. So there's the answer from Coffeezilla, but if you want the rest of his answer, I think his video covers it, and that's linked below. Are you guys ready to move on to Karen Reed? Are we ready? Ophi says, wait, are you live? I am. I'm live. I'm alive at the moment. I did not perish in the heat last evening, and here we are. Are you guys ready to talk about Karen Reed? I think we're ready to get to that, and then we'll move on to we'll move on to a lot more shade, won't we? Because isn't that what the Rust responses are all going to be? So much shade. But first, we need to get to Karen Reed. Let me make sure I have it pulled up. All right. Can we do a road so far on this? I don't even know. We're so far gone. Like, there is so much here. Let's see. We're gonna try our best. All right, Emily, you can do this. Road so far. The jury in the Karen Reed case was unable to reach a verdict, and the judge declared a mistrial, dismissed the jury, and set a date for a status conference. From the time that the jury was dismissed, before the status conference was even heard, the defense brought a motion to dismiss, arguing that the jury had in fact reached verdicts on counts 1 and 3 and was only unresolved or unable to reach a unanimous verdict on count 2. And for that reason, the judge should dismiss counts 1 and 3 and not allow the Commonwealth to retry Karen Reed on those counts. Count 1 being the most serious count against Karen Reed, which was the second-degree intentional homicide. Count 3 being the hit and run causing death. Count 2 is the confusing one that I broke down on a podcast that has a bunch of the lesser included crimes by statute. Those lesser included crimes are included by law. We went through the jury instructions and where there could potentially be confusion, and it seems in this case that there is. Jurors reached out to the defense and said, wait a second, we came to verdicts, but we didn't know that we were supposed to fill out the verdict forms if we didn't come to a verdict on count 2 or the lesser includeds in count 2, but we need you to know. So the defense made a motion to dismiss and then brought in supplemental responses. The prosecution made an opposition saying, no, we can do what we want. I mean, in my head, it was in Cartman's voice, but no, the verdict isn't a verdict unless it's taken in open court and put on a verdict slip, and that's not what happened here. So the Commonwealth said, we have the right to go and prosecute any of the charges against Karen Reed on a retrial. That retrial has now been set for January of 2025. What's coming up this week on Friday, August 9th, is a hearing on oral arguments regarding this motion to dismiss. The defense is arguing that this is double jeopardy. They don't have a lot of legal room to argue here because A, this doesn't happen often. Often juries are polled. These jurors were not polled. And the error can be remedied if you poll the jury. Is this your verdict? Is that your verdict? Does this reflect your verdict? So the defense made their motion, and then subsequent supplementals indicating more jurors had reached out. A juror reached out to the media and said, yes, this is all accurate. Then the Commonwealth made their opposition. Then the Commonwealth filed a supplemental that we're going to go over in just a moment. And the defense filed another supplemental yesterday. What the defense wants ultimately is for the court to dismiss counts 1 and 3. Legally, I don't know if the court can even do that. I truly don't. The law is not on the defense's side in this, but what most of you are going to say, but Emily, how is that right? Right. What is legal and what is moral are at odds here under the law as I see it. So if the court denies this motion, I think it will go up on appeal. What I think the defense ultimately wants is to be allowed to talk to the jurors about their verdict only, or bring the jurors in like they did in Murdaugh. Hey, juror number 1, did the jury reach a verdict on count 1? Yes. What was it? Did the jury reach a verdict on count 3? Yes. What was it? And that's it. So now we have this tension between what the law can do and what the jury seems to have wanted to do, but you need to ask every juror. You can't just go, well, 4 of them said that they reached verdicts, so the court's going to dismiss the counts. You kind of need to know if the jury was in fact unanimous. And the only way to do that is to ask the jurors, which should have been done before a mistrial was declared. But this jury no longer has any power over the case. The problem with that is that if you spend 9 weeks, well, 10 with jury selection, 10 weeks on a jury, and you render a verdict, or you think you render a verdict, and then you think you need to ask the judge, hey, we couldn't reach a verdict on this. What do we do? And the judge is like, I'm declaring a mistrial. How frustrated. I think the jury system deserves an answer on this question. And I think the jurors deserve an answer on this question. Imagine you're that juror, how wrong that would feel to you if you're like, you can't retry this woman for murder because we acquitted her of murder. So there is a tension in the law here. I don't think the judge can just dismiss the counts under all the law that we've seen. I think there is room to argue that the judge can inquire of the jury. And I think that's probably the defense's best argument, is to get the jury polled so that they can say, this was a unanimous jury. The error is in the way the jury instructions are written. The judge should have polled the jury. The defense didn't ask. The defense said they didn't have an opportunity to. The prosecution didn't ask. But I think the jury should be allowed to give their input here. And I think there's room under the law for that to happen. Then I think the only remedy is the Commonwealth dismissing counts 1 and 3, which they can do. So with all of that, we're going to take a look at the Commonwealth's response. We're going to take a look at the defense's new response. And I think the best outcome for the jurors and the defense is to allow the jurors to be heard via affidavit to the court directly, or having them come in and being asked. And then it's going to be on the Commonwealth to choose to dismiss the counts or not. And again, prosecutors are elected. So the people of the county have the ability to say to their elected officials, seriously, WTF with this. But you can't do that without all of the jurors. You can't do that on 4 jurors. You have to do that with all. But the law does not allow you to open the door into jury deliberations. I think there is a strong argument that asking the result is not asking about the nature of deliberations, though I can see the argument on the other side. Because they never rendered a result in court, asking what they did in the jury room is asking about deliberations. I think there's room to split hairs on that. And because I think there's room to split hairs on that, I think it's going to have to go to the appeals court. That's what I ultimately think is going to happen. When we come to this hearing on Friday, I just want to set some expectations. Chat, let's all take a breath and a long judicial sigh and set our expectations together. I don't think we're going to have a resolution on Friday. I think we're going to hear oral argument and the judge is going to take it under submission. This is not an easy, clear answer, I don't think. And if the judge does rule on Friday, it will be a denial. The judge choosing to do this or choosing to allow the jurors to be questioned is the legally more difficult result, right? Just denying it's a pretty easy result. Allowing the jurors to be polled is a more difficult result. So I think the judge taking it under submission allows the judge to contemplate what can be done here and truly what's the right result. But the result in the interest of justice, that is up to the prosecution to do. Do I think they should? Yes. Am I confident that they will? Nope. Nope, I'm not. But the will of the jury should be heard, and you can't really know what that is until all 12 are asked. Can they be asked? I think it's tough. And judges don't want to go against the law that they come before. So it is very reasonable. I guess reasonable is a loaded word. It is probable that the judge will kick this question onto another court and let the appellate judge deal with it and be like, above my pay grade, send it up to the appellate court. Y'all decide. I'm not doing it. Y'all decide. I think that is a high probability. If the judge denies this, it doesn't mean that's the end. It will go up on appeal. It is more probable that it will be denied because the result that the defense is looking for is not a usual result in Massachusetts. It would be asking for something new and something different and something that there doesn't seem to be much support in case law for. So when those are the factors, that is a question for the Court of Appeals. There is nothing clear. For those of you that are following along with my check-ins, I would call them, with the YSL prosecution in Georgia that I do on the Emily show that drops on Wednesdays, we talked about this with the judge's ruling about the ex parte. The judge sidestepped and do-si-doed around the ex parte question and went right to the code says the judge shall assign another judge. The judge didn't. The judge said, no, I shan't. And therefore, this is the answer to the question because the code was so clear. So the judge took the path of least resistance, which is what judges do, the path of least resistance to come to an answer. It says shall, you did not, there we go. Here, the path of least resistance is to not let the jurors be questioned and let another court decide it. I know that's not the result a lot of y'all want. It doesn't feel like the right result. I think the will of the jury should be heard. But I think it's going to take an appellate court to get there. I really do. By the way, tomorrow there's more YSL updates from me. There's still hearings going on today. So let us continue into Emily, share your different screen. I have a whole different workflow. Changing workflow is so challenging, but there's a whole different workflow with the way things have not been working well with StreamYard lately. So forgive me as we workflow. This is the Commonwealth's, not the Commonwealth's opposition. We already did that. This is the Commonwealth's response to it. This came out on Friday. If you follow me in our app or on social media, I gave a quick update as I was leaving my house to go work at the fair on Friday, because of course this happened as I was walking out. Well, I became aware of it as I was walking out the door to go do that. So let's talk about it. Let's see if I can make this a little bigger. And like everything in Massachusetts, these are all like screenshots of screenshots because Massachusetts does not have any type of digital document delivery system, which is a delight. But after all the courthouses went down with other types of issues, this might be helpful to the court to not have everything digitally. It's frustrating as fuck to me. Commonwealth's post-trial notice of disclosure from, this one's not stamped. This was from Friday, August 1st. Now comes the Commonwealth. Let's see if I can embiggen just a little bit. There we go. Now comes the Commonwealth in the above captioned matter and provides notice regarding the defendant's post-trial claims regarding the jury deliberations. In the languaging of it, the Commonwealth is still saying, this isn't proven. These are claims. Defendant's post-trial claims regarding jury deliberation. On Sunday, July 21st, ADA Adam Lally received an unsolicited voicemail on his office phone line from an individual who identified themselves? Chat? Chat. It is who's grammatically correct? Chat, I need to know. Because I truly don't. Would it be themselves? Is it their selves? Help me. Chat, help me. Thank you. Who identified themselves as a juror by full name and seat number. This individual stated, quote, it is true what has come out recently about the jury being unanimous on charges 1 and 3. Thank you, chat. Chat says themselves. Appreciate you. Thank you. What if any self? The juror identified what if anyone was themselves. All right. Thank you, chat. It is true what has come out recently about the jury being unanimous on charges 1 and 3. On Friday, July 26th, ADA Lally received another unsolicited voicemail at his office, his phone line, from the same individual who stated, quote, can confirm unanimous on charges 1 and 3 as not guilt and as of last vote, 9-3 guilty on the manslaughter charges on the lesser level manslaughter charges. This is what I had assumed, that it was not on count 2. And if you watch that podcast, I tried to break it down as best I can. Lesser includeds can be confusing, but I tried to break down what the main charge was of the DUI causing death or the operating under the influence causing death, and then what those lesser included charges were and where some of the confusion might be, because those charges were never even discussed. And they're confusing. And the jury instructions, I can see where the confusion is. So, lower level manslaughter charges. So they were hung as to the lesser included. That's what made the most sense to me. That's where I thought it was. And there we go. The Commonwealth did not respond to this individual, as the Commonwealth is ethically prohibited from engaging in discussions about the jury's deliberative process. This is the heart of the issue. The defense does not see this as the deliberative process, and the Commonwealth, I think, in oral argument is going to continue to argue that the defense's answering of phone calls or talking to the jurors is ethically prohibited. And the Commonwealth is like, we can't talk to you. These are our ethical rules. But and we went through this at length, so I'm not going to do it again to y'all, I promise, but is the result part of the deliberative process? Emily, do lawyers argue over the meaning of words? Like literally all the time. It's 90% of lawyering is what the definition of is. Is the vote count part of the deliberative process? Or is it the result of the deliberative process, which therefore is not the process? It is the result. And I think there is quite a lot of room to argue there, but until an appellate court says, yes, you can ask about a result, I don't know if this judge will do it. But it's the only thing that makes sense. In Massachusetts, you are not prohibited from, I'm pulling up the defense's last, or the prosecution's last motion. You are not prohibited from inquiring about a jury split or inquiring and verifying a verdict. So if in court you can verify, this is where my train of thought goes, right? If in court you can inquire of each jury, you can poll the jury and say, juror number 1, is this your verdict? Yes. Juror number 2, does this reflect your verdict? Yes. If you can do that, then that's not the deliberative process, because it is part of the logical chain of if you're allowed to inquire in court, if you're allowed to poll the jury, then the law necessarily separates the two. Polling the jury about the result and talking about the deliberative process. The deliberative process is like none shall pass. But jurors are polled regularly, frequently, and in every jurisdiction I've ever seen a jury trial carried out in. It's not prohibited in Massachusetts. And I think that logic gives argument to the law that polling a jury is separate than asking about the deliberative process. That's how my brain gets there. Because the result the Commonwealth is arguing just doesn't make any sense. The way the Commonwealth is arguing it is you can never poll the jury. How does that make sense? That doesn't make logical sense at all. So that can't be what the law intends. And if that's not what the law intends, then you can ask. All right, I am interested by the Commonwealth saying that they received these voicemails on Sunday, July 22nd and Friday, July 26th, What I'm looking for in my files real quick is the date of the Commonwealth's opposition to the motion, because I need to refresh my recollection because I don't have it off the top of my head. Every lyric to every song I grew up listening to, yes. The date of the opposition, no. It was filed July 12th. So the Commonwealth has made clear to state that they were not contacted until after their first motion was filed. I didn't want to unfairly chastise the Commonwealth for not putting it in their other motion. Sunday, July 21st, Friday, July 26th, they filed their opposition July 12th. The original motion and affidavits were filed July 8th. So these came down right after 4th of July. And in the first one, Alan Jackson said he was contacted on July 2nd. And Yanetti's affidavit said he was contacted on July 3rd. So these were happening right after the jury came back with a hung verdict, or a unable to reach a verdict. Okay. On Friday, July 26th, ADA Lally received another unsolicited voicemail. Same individual, can confirm, and it's everything we've heard before. And this is what was told to reporters as well. I wonder if it is the same juror. It might well be the same juror that spoke to the media that is confirming to the Commonwealth. Like, I'm telling you, though. Oh, God, I'd be so pissed if I was one of these jurors. But I also would just be like, excuse me, Your Honor, but we have verdicts. What are we supposed to do? Me just blurting shit out. Yep, absolutely, probably would. No, absolutely would. It goes on to say, similarly, the Commonwealth received emails from 3 individuals who identified themselves. There's the themselves as jurors. These individuals indicated they wished to speak anonymously. On July 16th, the Commonwealth responded to the emails. But when did you get the emails? Because your opposition, though the opposition leans very heavily into there's no legal remedy, but it's missing, isn't it? On July 16th, the Commonwealth responded to the emails by stating the Commonwealth would, quote, welcome the opportunity to discuss the evidence or the Commonwealth's case. However, we are ethically prohibited from inquiring as to the substance of your jury deliberations. That would include your individual or the jury's collective thought process, the content of your deliberations, or the reasons for your decisions. Chat, does any of that say, or the result of any vote? Does any of that say that? Because all that's missing. And I think what the Commonwealth has said here is exactly what the law says. The Commonwealth is by law prohibited from content of deliberations, reasons for decisions, or thought process. None of that says anything about a vote or the result of a vote. I think the two can be differentiated. I think the two can be easily differentiated. But that's just me. It was further explained that the Commonwealth could not promise confidentiality and that the substance of any communications may necessitate disclosure to the defendant or the court. All 3 jurors declined to further communicate with the Commonwealth and provided no information about the jurors' purported votes. Well, of course they provided no information about the vote after you told them that, but the Commonwealth is not wrong. If jurors disclose things to the Commonwealth has an obligation to turn anything that's said to them over to the defense. So yeah, they would have to do that, including the identity of the juror and the seat number. They would have to say that. So I think the Commonwealth is, I don't think they're wrong here saying we can't guarantee that it's confidential to the DA's office. We would have to disclose this to the defense. and they would have to disclose it to the defense. So I think, I don't know, I think the DA's office saying, oh yeah, it'll be confidential would be unethical. They have to disclose because they can't. So the DA's office is like, yeah, we can't guarantee confidentiality, but we could, we can keep it. I think they could have gone further. It has to be disclosed to defense attorneys and defendant. It does not have to be put in court documents. It can be redacted out of court documents. It doesn't have to be disclosed beyond that, but it has to be disclosed to the defense and the defendant. That they have to say. I think they could have gone further to clarify. It needs to be given to the defense and the defendant, but any other filings can be redacted. I think they could have gone further. They chose not to. So they say in here, the Commonwealth could not promise confidentiality and that the substance of any communication may necessitate disclosure to the defendant or the court. They could have gone further than that. But we will see, because this is all going to get argued about on Friday. So Yanetti responded, and Yanetti responded first to the media and then to the court. Let me pull up his statement to the media first, because this was a quick statement on Friday. And then we will pull up their response in court. So let me grab that. I grabbed a screenshot of that. Let's see. And we will just pull that up real quick. Hopefully, yes. All right, this was Yanetti's statement to the media. On the record, the Norfolk County District Attorney's, Emily, fail. What are you doing? Okay, stop. Oh, goodness. Apologies, chat. Apologies, chat. Yanetti's response on Friday, August, I think this was Friday. What was Friday? The 1st, the 2nd, whatever last Friday was, the 2nd. The Norfolk County District Attorney's Office in its new filing finally admits that they have received the same information that the defense has received from sitting jurors. Karen Reed was acquitted on 2 charges, including murder. We now expect the DA's office will do the right thing and dismiss at a minimum indictments 1 and 3. They've already indicated they're not inclined to do any of that. Of course, our position remains that all 3 indictments should be dismissed because they have charged the wrong person. Should they persist in pursuing this wrongful prosecution, we will stand ready to defend our innocent client no matter how long it takes. Can the prosecution dismiss counts 1 and 3? They can. Based on their opposition, do I think they're gonna? No. Will I be shocked if they do? Yes. Does it seem to be the right result here with this information? It does. Based on this information, that seems to be the right result. But I can also understand, and you might disagree with me, but I can understand where the DA's office is like, if we only hear from a handful of people, we're not doing anything. If we hear from all 12, maybe we will, which is why I think what we'll see the defense doing in their argument, what I would do if I was the defense, is lean into, Your Honor, we need to at least know from all 12 jurors. And the judge is probably going to say, I can't make the jurors say anything. You can, though. But I think you need to hear from all 12 jurors. I don't think the DA's office is going to dismiss based on a few jurors. They're going to want to hear from everyone. So let's go to the 3rd supplemental memorandum that was filed yesterday morning. All right, let's switch screens around and head into that motion. So much to cover today. All right. Are we ready? Are we ready, chat? Let's see what Yanetti had to say yesterday. All righty. Nope. There we go. We're professionals here. We'll get it eventually. Filed August 5th. This is Defendant Karen Reed's 3rd supplemental memorandum in support of her motion to dismiss. No, the blur on the documents is not you. You do not need an eye exam. It is not your internet. It is just the nature of these documents from Massachusetts, because they're like screenshots of screenshots, because Massachusetts does not do digital document delivery. Is that frustrating as somebody who covers documents? Yeah, it is. Real frustrating. But also it is what it is. Now comes defendant Karen Reed by and through undersigned counsel and submits this third supplemental memorandum in support of her motion for dismissal filed July 8th. As reflected in the attached supplemental affidavit of David Yanetti, a deliberating juror, in this case juror B, placed an unsolicited phone call to attorney Yanetti confirming that the prior affidavit of David Yanetti accurately quoted their text messages saying, quote, "It was not guilty on second degree. No one thought she hit him on purpose or even thought she hit him on purpose." In the Yanetti affidavits, those were the game of telephone affidavits where someone reached out to Yanetti and was like, "I heard it from a friend who heard it from a friend who." It was, this person was on a Zoom call and that person told another person that told Yanetti about what was on the Zoom call. It was such a game of telephone. The affidavits from Alan Jackson were, jurors told me this. So this is talking about the juror who they've assigned number B2. They've assigned letter B to this juror. Not B2, not our B2. We love B2, but they've assigned B to this juror. And this juror had been one of the game of telephone jurors. So this game of telephone juror reached out and said, "Yeah, that was accurate. I'm game of telephone juror, and let me tell you directly." So they're closing that hearsay gap, even though all of this is still out of court unsworn statements to attorneys that are being purported to be true, told in court. So there are still issues, but at least we have less of a gap here. Juror B, quote, clarified that they meant to write, "No one thought she hit him on purpose or even knew she had hit him." Which, given everything, that makes sense. Given the trial that we watched and where the jurors are stuck and what the lesser included say and what these two counts have in common, this makes sense. Count 2, in some of its lesser included, allow for accident. Counts 1 and 3 both involve knowing and a very strong knowing component. So with that very strong knowing component, this makes sense. Let us continue. Let's see. Juror B further confirmed, quote, "The jury reached unanimous not guilty verdicts on indictments 1 and 3, and that they believe every member of the jury, if asked, will confirm that they reached not guilty verdicts on indictment 1 and 3. And I think we're going to see the defense again leaning into, Your Honor, you've got to poll the jury. And then we will see a campaign of public pressure against the DA's office. If the jury is polled and all 12 jurors say they unanimously agreed that she was not guilty on 1 and 3, you will see a push to push the DA's office to do the right thing. Based on the attached affidavit and the reasons set forth in the motion and all the rest of it, the defense renews its contention that the jury acquitted Karen Reed on counts 1 and 3, or alternatively, there was no manifest necessity for a mistrial. Double jeopardy attaches. The court, she cannot be retried on, the court must dismiss. If the court, for any reason, would not credit the affidavits of counsel in the same manner as a court would credit identical affidavits from a juror in question, or an affidavit that the juror has reviewed counsel's affidavit and confirms the accuracy, the defense requests permission to initiate contact with jurors A, B, D, and E for the sole purpose of asking them to affirm the accuracy of the affidavits. I hope that they would allow for all of that. So somewhere there's a Yanetti supplemental that states all of that. I have not seen it, but all of the supplementals state exactly what's in the motion. So now you have a juror saying, yes, I was the juror who you heard from a friend of mine, and this is what I meant to say in that text, and this is what it is, and I confirm it. So we have 4 jurors directly stating to the defense, first person, that they acquitted. We have another juror, a fifth juror, that we've heard from via a friend and who has not come forward. We have a juror who's come forward and asked the court to keep their identity sealed because they were deeply concerned for their own safety and well-being. And then we have jurors who have come forward to the Commonwealth. We don't know if those are additional jurors or the same jurors. I am not going to suppose that those are additional jurors. I would think the jurors who have been very vocal about this would probably be the same jurors that have been vocal on both sides. And the jurors who want nothing to do with this are keeping their mouth shut. And I don't blame any of the jurors for how they're responding to this in this highly contentious case. And well, you all saw how mad I was the day that we got the juror affidavit about how concerned they were should this become more public and how concerned they were for their own well-being. And I worry that that affidavit is going to loom large in the judge's mind when this hearing is had. Because how can it not? All right. We've got a few super chats on this. We're going to go to them. First of all, Private Info, thank you for the super chat. For some pizza and beer later. Yes, I might modify it to pasta and whiskey, but yes. But yes, we're going to chat a little bit about this. I'm going to go through some direct questions on this. We'll talk about Rust and then we'll get to all of your questions. And that's where we're at. Ronnie in the chat said jurors are entitled to keep their mouth shut. They are. It's going to be hard. It's going to be hard for the judge to overcome that affidavit, I think, and force the jurors to come in and state that they came to a verdict. I think it can be done anonymously. I think it can be done by affidavit, but I think you need to know from all 12, if for nothing else, then that the Commonwealth can say all 12 jurors confirmed this, and so we're choosing to dismiss. I know many are going to be disappointed on Friday when the judge doesn't rule. I don't think the judge is going to rule. So we're going to answer a few questions on that before we hop and skip down the road to get to the Rust and all of the shade. So going through the additional new documents today, we have looked at another supplemental from the defense indicating that one of the, who I'm calling the game of telephone jurors, whose acquaintance, friend, or somebody they communicated with came forward to David Yanetti. That juror has come forward directly to David Yanetti and confirmed their statements that the jury didn't believe Karen Reed knew she hit John O'Keefe with her car, that they were unanimous on not guilty on counts 1 and 3, and they were stuck on count 2 on the lesser included. Let me pull up that exact quote, actually, because it was really helpful. Let's see. No one thought she hit him on purpose or even knew that she had hit him, which means to me that the jury was contemplating that John O'Keefe was hit by a vehicle, hit by Karen Reed's vehicle, and she did not know, which is consistent with that 9-3 leaning towards guilt on the lesser included that numerous jurors have now discussed. That's consistent because counts 1 and 3 both require intent. You have to know that you've hit someone, and you have to, in count 1, do it on purpose, and in count 2, know that you did it and leave. So those statements are consistent with what the jury is telling us that they intended to do. The Commonwealth also filed a supplemental stating that a juror had called and left voicemails on Adam Lally's phone and that jurors had emailed Adam Lally and said they reached verdicts. And Lally responded, "We can't promise confidentiality because things you say might need to be disclosed to defense or the court. And we can't talk to you about your thought process, your deliberations, but none of that says they can't inquire as to the result." So oral arguments on Friday, August 9th are going to be very interesting in this case. Here's what I think we will see. The court taking it under submission. I don't think the court's going to rule on this on Friday. And I think the court will do a written ruling down the road. The prosecution arguing that the court can't inquire on any of this and it's not double jeopardy. The defense arguing that the court must dismiss these counts because it's double jeopardy, and in the alternative, arguendo if you will, arguing that at a minimum, the court needs to at least poll the jury or allow the attorneys to get affidavits from all 12 jurors to confirm that they were in fact unanimous. I think that is the best outcome and the most possible for the defense. The court is not going to dismiss these counts. They're not. The defense's best result here and the result they can possibly obtain and would be the best result for them is to at least be allowed to get affidavits from all 12 jurors confirming that that was their result. That gives them somewhere to go. If the court denies all of this out front, then it will go up on appeal. And that's where we're at before the hearing on Friday with the Karen Reed case. I'm going to answer a few of your questions and then we're going to zoom over to Rust. And then we're going to read lots and lots of snark and Judge Summers' big bad. So let's answer a few questions before we move on to that, just specific about this. This is going to be tough. So Tammy E said the result for count 2 was guilty 9-3. It was for the lesser included, not count 2. But yes, it was for the lesser included on count 2. Negotiator said, I don't think this is the case, but for argument's sake, does the court have to consider the possibility that the jury came to this conclusion after the trial? In any case, the court has to consider that. Absolutely, they do. But if that's true, you would generally see 1 or 2 jurors going, no, I don't agree. I don't agree with that. Let's see. Music to My Soul said, I know neither side reviewed the elements of the charges in their closing. Would they have been allowed to do that after Judge Bebb ruled against the defense motion to split the charges? Is that applicable? The splitting the charges is not applicable to what they can argue. They could have asked the court for more time for their closing to do that, and they didn't. So they could have asked for more. Boffle Waffle said, do judges go through any kind of training? Yes, they do. It varies by jurisdiction what that looks like. And depending on how busy it is, that can be a year or more in, but yes, they do. What's unusual to me in Massachusetts is the judges rotate through sitting on the bench for criminal cases and then sitting on the bench for civil cases. For attorneys who have only worked criminal and sit on the criminal bench, I can imagine if you throw them into civil, they're like, what in the world do you want me to do? They are two very different systems. Like law is law, but it is very different. So in Massachusetts, they rotate between criminal and civil, which is wild to me. Carol said, in 30 years as a trial lawyer civil, only one judge treated me disrespectfully. I think I just rubbed him the wrong way. Maybe it was my pantsuits. Oh, I love to piss people off in a pantsuit. Carol, I'm with you. Most of the judges I had were great. Occasionally they get snarky, but most of the judges I had were great. So let's see. Tracy says, forgive me if this has been asked, but if the investigators that have been removed and or are under investigation, can the defense bring that up if they testify? If there is a retrial and those witnesses testify, yes, absolutely. Don't say absolutely, Emily. It's the law. Yes, there could be limitations to that and limited circumstances to that. But yes, discipline based on their actions in this investigation can absolutely come up to impeach them. Yep. Let's see. You mean they could have asked for more time to review the elements after she read the jury instructions? Music to My Soul, they could have asked for more time to do their closing. They were each limited to an hour, and I think they could have both asked the judge for more time so that in their closing arguments, they could have done that. Both sides seem to say an hour's fine. So they went with that. Charlotte ASMR said, follow up if there's separate jurors that reached out to the DA versus the 5 to the defense, that's like 8 individuals speaking out and wanting to be heard. Is there a majority rule to be taken into consideration? No. Jurors has to be unanimous, or verdicts have to be unanimous. And what the defense is asking goes kind of against the grain of the case law. So they need to know what all 12 have to say here. And I would not assume that the 3 jurors that reached out to the DA are in addition to those that the defense was talking about. I would think that they are probably the same, and that those who don't want to say anything have not said anything. Let's see. Rolling Along said, did Bev purposely mislead the courtroom by stating she would talk to the jurors privately so everyone would think she meant poll? No, polls should generally be done in public. I was very surprised that she didn't. Normally when judges say, I'll speak to the jury, it's thank you for your jury service. We're keeping your names anonymous. No one has the right to contact you. If you have any problems, this is who you contact. It's normally administrative stuff. So no, and Yanetti practices in this jurisdiction and should know the practices. Jackson doesn't practice in this jurisdiction, but Yanetti does and should have known. Let's see. Charlotte said, doesn't the defense already know the identity of the jurors if they're the same ones who have spoken to the defense? Yes, they should. Cy Hutch H or H said, summoned by the app. Hey ya from Bristol, UK. Hey ya in Bristol, UK. And I'm glad the app summoned you successfully. It is always a work. Nicole Link said Logan is now the former United States champion, which I celebrated when he lost on Saturday. Well, Nicole, this is always happy news. I had no idea there was wrestling this week. Between life and kids going back to school and Olympics, I am so far behind on literally everything. Marilyn said my grandson got picked to mutton bust at the rodeo. Look, rodeos are a good old time. I love it. Crafty Crafty said, is the next Karen Reed hearing Friday? Yes, it's Friday. Yes, it will be streamed unless something wild happens. And yes, I will be streaming it. So if you want to watch it live with me, absolutely do. Absolutely do. We're here for it. All right. Are you guys ready to zoom over to Rust? And then we will come back to all of the time for Q&A at the end. To all of our new members, welcome. To everyone who gifted memberships, thank you. We will have upcoming members only live and some behind the scenes things for you too. Susan, thank you so much. I have some behind the scenes BTS for members next week. Sweet Pea said, former marching band mom here. Second base, bless you. Look, band parent is, it's busy. I mean, like any sport that has lots of equipment and encourages things, but like hockey parents, very busy. The equestrian parents, incredibly busy. It just is. But you know what? It's how I want to spend my time. So I'm good with it. It's always illuminating, and getting to see kiddos in their element as a quiet observer is lovely. So Courtney in the chat said, I embarrassed a teacher with a personal story and made her change the project, wrote about surviving child abuse, and she sent me to the guidance counselor. Courtney, A, good for you. And B, sometimes they don't know what they're uncorking in the things that they ask, which is why lighthearted at the beginning. What's a hobby we may not know about you? Something like that. I don't know. It just seems that it's such a hard question getting into what's important about you. I don't know. So you guys are saying, what time is the Karen Reed hearing on Friday? I believe it's 2 p.m. local time Eastern, which would be 1 p.m. here, but I will let you know in the app. I believe it is 2 p.m. Eastern. That said, the court can change it if they need more time for the hearing. So I am not settled that won't shift. So again, that might shift. I will notify you on YouTube and in the app. And I will try to let you know Thursday when we know what's happening. But I won't know what's happening Thursday till just yet, because I'm waiting to see if that Corey Richens hearing on Thursday is going to be streamed. And if it is, we're going to Utah on Thursday. Utah, give me 2. All right. You know what we need to give me? Give me some sassy Judge Summer. That's what I need right now. Because the judge has a lot to say. We have a written ruling from Judge Summer in the Alec Baldwin Rust case. We are going to go through most of it. I will not be going through some of the summaries of the law. I'm looking for the sass. I'm here for the sass. I am here for the sass. So that's what we're going to do. Let me swoop and make sure our documents are pulled up, and we'll do that now. So are we ready to go to Rust? Let's go. The Rust case is done, but not over. We have two Rust things to talk about today. First up, we're going to be talking about the judge's written ruling in the Baldwin dismissal. Yes, the judge made a very thorough ruling from the bench, but the judge also memorialized that ruling in writing, and we are going to go through and see what she has to say about the prosecution. Why? Because Kari Morrissey is still the prosecutor on the Hannah Gutierrez Reed case. And the Hannah Gutierrez Reed case has a plethora of motions still pending that Kari Morrissey is arguing. Snarkily, like so much snark. So we're going to see what Judge Summer has to say about Alec Baldwin's dismissal as we get into this motion. Let us do that. All right. This is the order granting defendant Alec Baldwin's expedited motion for dismissal and sanctions under Brady, Giglio, and Rule 5-501. Procedural summary. On July 11th, defendant filed his expedited motion. God, it feels like that was 100 years ago and like yesterday. It feels like 100 years ago that this happened. Let's see if we can make this a little bit bigger. There we go. On July 11th, defendant filed his expedited motion. The state did not file a response. Do you remember that the court was like, no response? Huh. I think that's when Kari first started to realize that, like, girl, you in danger. But on July 12th, the court entertained oral arguments by the parties. In addition, the court conducted an evidentiary hearing in furtherance of resolving the motion. During the evidentiary hearing, the court admitted evidence outside the presence of the jury. 5 witnesses gave testimony. The crime scene tech Popple, the lead investigator Hancock, Seth Kinney, Lieutenant Brandel, and Kari Morrissey. At the conclusion of the hearing, the court granted the defendant's motion and verbally explained its reasoning. The court enters the instant order in accordance with and in furtherance of the court's verbal ruling. Factual background. January 19th, a Santa Fe grand jury charged defendant Alec Baldwin with 2 alternative counts of involuntary manslaughter in connection with the October 21st, 2021 death of Helena Hutchins. February 26th, the court entered a scheduling order scheduling the parties to make their respective discovery disclosures within the timeframes set forth in the rules. February 26, 2024 order. Further, the court's scheduling order provides, quote, following initial discovery disclosures, the parties have a continuing duty to disclose and make available supplemental discovery within 7 days of the receipt of such information. So not only are there like rules about that, the court also literally spelled it out. If you get more shit, turn it over within 7 days. Pretrial litigation, and we covered all of this. Pretrial litigation. During pretrial litigation, defendant Baldwin filed 4 motions concerning allegations that the state had failed to comply with the court's scheduling order regarding discovery. First, on January 24th, Baldwin filed an expedited motion for relief for the state's Brady law disclosures related to the firearm. This motion concerned late disclosures made by the state relating to expert witness reports and statement by expert witnesses. You know, the Hague reports. The reports and statements bore on the functionality of the firearm that discharged the bullet that killed Miss Hutchins. Although the court found that the state had culpably made late disclosures responsibly, the court denied this motion on grounds that the defendant had not established the materiality of prejudice as defined in relevant case law. So the court's laying the groundwork of the prosecution's other errors. In distillation, the court reasoned, quote, defendant was now aware of and able to use the late disclosed discovery in preparation for and during trial. July 3rd, 2024, order denying the expedited motion. Second, on June 24th, Baldwin's attorneys filed a motion for relief under Brady law disclosures related to non-firearm discovery. This motion concerned late disclosures by the state of thousands of files, including over 150,000 pages of documents and dozens of gigabytes worth of data. So with that, they charged Baldwin. Then they dismissed it. Then they indicted him. How are you not ready to turn over discovery? How? You knew. This is so wild. Although, again, the court found that the state had culpably made late disclosures, the court denied this motion on grounds similar to those previously addressed, saying, look, the state has made late disclosures, but you have it now. You are not materially harmed by getting it late. I don't know. I'd feel personally attacked by 150,000 pages of discovery. Nevertheless, the court says, in so doing, the court acknowledged the prosecution's representation that, quote, the state conducted a complete audit of its discovery disclosure files as soon as it was aware of the potential problems that existed and had cured any discovery disclosure issues. So the court is like, this is the background on why the court was just like, we're done. Third, on June 26th, defendant filed a motion to compel disclosure and impose sanctions. The witness statements, expert witness statements. I lost where I was in that sentence. Apologies. The motion concerned late disclosures made by the state in relation to expert witness statements and also asserted that the discovery issues relating to witness statements remained ongoing in the days leading up to trial. Defendant's reply additionally claimed that, quote, between June 27th and 29th, 2024, co-special prosecutor Orlinda Johnson, a former federal prosecutor, disclosed over 1,100 pages of documents that Morrissey had previously refused to provide. And that's regarding that quote comes from the July 5th reply to further support the motion. The court verbally denied the motion on July 8th after the parties represented that they would conduct a meet and confer to resolve the issue. Issue after issue after issue. Further, fourth, on June 27th, defendant filed a motion to exclude the opinions of Lucian and Michael Hagg under the rules. In pertinent part, the court denied this motion on the basis that one, contested disclosure was not late, and two, or B, arguments addressing the other disclosures duplicated arguments set forth in the previous motion, and that previous motion was denied. So the court's like, we denied the last one, we're denying this one. Ultimately, defendants' filings discussed above demonstrate that the Senate the Senate didn't do shit. The state that the state continually made late disclosures to the defendant throughout the pretrial litigation and even in the days immediately preceding trial on July 9th. What's so wild about this is not only is there a co-defendant they went through trial on, so like, you knew, but also they had dismissed and refiled. Well, indicted. You dismiss and reindict, and then you're still like, oh, but we don't have all the discovery data there? Come on. What? Stop it. It's just bananas that this wasn't like together. It goes on. The defense filings discussed above demonstrate that the state continually made late disclosures to the defendant throughout the pretrial litigation and even in the days immediately preceding the jury trial beginning July 9th. Nevertheless, on July 1st, the state filed a certificate of compliance in which Prosecutor Morrissey stated that she had, quote, transmitted to counsel for defendant pursuant to provisions of Rule 501 all materials and documents in her possession enumerated in the provisions of Rule 501 for disclosure by the state. So a certificate of compliance with discovery. Your Honor, yes, there's been problems. Yeah, sorry about that. Apologies. But we're good now. We're good now. We're good. As of July 1st, we're good. It's all been turned over. Jury selection and jury trial days 1 and 2. Oh, we're going to get like a full. I need lip gloss. Which one do I want? This. Emily, do you have 9 on your desk? 7, but yes, 9 is the number that we went with. All right. We needed some hydration. Trial days 1 and 2. On July 9th, the court impaneled and swore in 12 jurors along with 4 alternates. On July 10th, y'all were here with me. The parties made opening statements. 4 witnesses gave testimony. Nicholas Lafleur, Lieutenant Benavidez, who was great, Deputy Lujan, and crime scene technician Popple. Further, the court admitted numerous exhibits into evidence on July 10th. On July 11th, Popple continued her testimony in the presence of the jury. Relevant to this order on cross-examination, defense asked Popple about ammunition submitted to the sheriff's office by a quote-unquote Good Samaritan near the conclusion of the trial of Hannah Gutierrez. Let's see. Mr. Spiro, quote, and a Good Samaritan the court pulled the freaking transcript to write their order. Girl, you in danger! When the court is going to the trial transcript to quote it directly to how bad it is. Oh, boy. Oh, dear. Mr. Spiro, quote, and a Good Samaritan walked into the police station and gave you the lethal ammunition, didn't they? That assumes facts, not in evidence. Ms. Popple, after the Hannah Gutierrez trial, there was an individual that came into the police station and stated they had ammunition. See, the issue with the question is the lethal part, but the answer was they stated they had ammunition, Mr. Spiro, and they turned in the ammunition. Popple, yes. Spiro, and they gave it to you, right? Popple, yes. Defense's questions further intimated that these rounds were related to the Rust investigation. Mr. Spiro, quote, and they told you that this was the ammunition that ended up with Seth Kinney that killed Miss Hutchins, right? Popple, I do not recall their statements. Spiro, okay, but you didn't, he told you it had to do with the Rust shooting, correct? Popple, yes. Defendant's cross-examination further elicited testimony that the sheriff's office inventoried the ammunition and a supplemental report concerning the circumstances of collection of the ammunition in a non-Rust investigation case number. And then they quote the transcript again. The court is pissed. Spiro, quote, I'm asking you, isn't it the case that law enforcement likely has the matching rounds to the ammunition that killed Miss Hutchins? Popple, I don't know. I do not know. Spiro, and you do not know because you made a doc report about this and did not put it with the rest of the Rust evidence, correct? Popple, these rounds were not placed with the rest of the Rust evidence, correct? Spiro, nor were they sent to the FBI for testing with the Rust evidence, were they? Popple, no, they were not. Defense elicited further Defense elicited further testimony from Popple, establishing that defendant was not given the opportunity to inspect the newly collected ammo when defendant inspected ammo inventoried under the Rust investigation case number. Spiro, are you aware whether the sheriff's office ever informed the defense that a Good Samaritan came in and turned in this ammunition? Popple, I do not know. Fair, that's not her job. Spiro, when the defense came to view the Starline brass nickel primer live ammunition with you, you didn't show them this, did you? Popple, I did not have an evidence viewing with the defense. That was my coworker. Spiro, your coworker didn't show this to the defense, correct? Popple, I do not know. That part of Popple's testimony is fair. Popple wouldn't have known. But the point still stands that nobody showed this to the defense. Mr. Spiro, do you have any reason to believe your coworker showed this to the defense, given that it wasn't put in the same inventory as the Rust case? Popple, no. On redirect, the prosecution identified the Good Samaritan as Troy Teskey, a close friend of Hannah Gutierrez Reed's father. In an effort to rebut the defense's cross-examination, Morrissey elicited the following testimony. Oh, danger, danger, danger. Miss Morrissey. And let me ask you, Miss Popple, the ammunition that the Good Samaritan, Mr. Teskey, the close friend of Hannah Gutierrez's dad, the ammunition he brought to you after her conviction, you still have it. Popple, yes. You can bring it here and show it to the jury, right? Popple, yes. And they can see for themselves that it does not match the live ammunition from the set of Rust, correct? Yes. And that's obvious just when you look at it, is it not? Yes. Oh, danger, danger. Because that's not true. Those last two, the jury can see for themselves that it does not match the live ammunition for the set of Rust. Correct? Yes. And that's obvious when you look at it, is it not? Yes. Boom. What was so hard about all of this going down is that in the moment you're watching this going, wait, what? And in the moment you're like, oh, so the defense is making a real big deal out of like ammo that doesn't even match. And we saw all the pictures of the ammo that doesn't even match. And the defense has thrown a lot of stuff up against the wall to make it stick. That's what the defense does. But when the judge tore open the ammo and there was ammo that matched the other ammo, it was such a big moment that it's hard to remember that this all happened the day before. But seeing it all in writing, it's really bad. Ooh. Following Popple's testimony, defense alerted the court of their intention to file a motion regarding the state's failure to disclose to defendant the supplemental report and make available the Teskey supplied ammunition. Thereafter, the jury heard testimony from two additional witnesses, Pieta and Hancock. The court recessed for the day amidst the state's direct of Hancock. Jury trial day 3 and the motion hearing. On July 12th, outside the presence of the jury, the court considered initial argument by the parties to the defense motion. Defense's argument primarily focused on the state's failure to disclose the supplemental report and lack of opportunity to inspect the ammo. The state's arguments primarily focused on the purported provenance of the Teskey supplied ammunition. Special Prosecutor Morrissey proffered Mr. Teskey is Thel Reed's close friend and Teskey stores Mr. Reed's ammunition. Teskey is a retired police officer who has a whole bunch of security at his property, so Thel has 300 rounds of live 45 ammo, and he and Seth are hired by the producers for the show 1883. Special Prosecutor Morrissey continued, so they get hired to do what's called a quote-unquote cowboy training on the set of 1883. I thought it was cowboy camp. So the cowboy training is where the gun experts, that being Thel and Seth, take the actors to shoot real guns with real ammo. Further, Special Prosecutor Morrissey stated, when they originally went to the cowboy training camp in Texas, they didn't take all of Thel's ammo. They took a certain amount of it, and then Thel left some in Troy Teskey's garage. All of this ammunition came from the same place. This was all from basically the same batch of ammo that Thel had that he got from an ammunition manufacturer in Arizona named Joe Swanson. That's why all the boxes had that JS label on them. Prosecutor Morrissey elaborated that Thel and Seth took 300 rounds to go to cowboy training camp. Seth then takes the leftover rounds back to PDQ. With the respect to the Teskey supplied ammunition, the prosecutor further explained that during the initial investigation of the Rust incident, Teskey sent to Seth Kinney a photo. Seth Kinney, in the middle of everything. I need his phone records. How many butt dials does Seth Kinney have during this period of time? I'm curious. Teskey sent to Kinney a photograph of the sample ammunition in Teskey's possession. A sample. That does not say all. A sample of the ammo in Teskey's possession. That photograph, look at this photograph. Okay, that photograph was sent to Hancock and Morrissey. And Morrissey also received a copy. The prosecutor proffered, when you look at this photograph, no, damn it, it says when you look at that photograph. When you look at this photograph, and I'll blow it up for you, you can tell these are not similar to the live rounds that were found on the set of Rust. But did you catch the word sample? sample indicates that that's not all of it. Further, Morrissey stated, I came into this case, I look at the ammunition that was taken from PDQ. I understand from the witnesses that the ammunition was sourced originally from Thel. It was sourced from Hannah's dad. It's not a match. Not only is it not a match when you look at it, it's not a match when you send it to the FBI and ask them to conduct chemical testing. The prosecutor continued, the photograph that was sent to me in the photograph that was sent to me is the photograph in the middle. Footnote 3. That is not the same ammunition. You can tell from looking at it. It has a different projectile shape. That's not the same projectile shape. That's not the same casing. This isn't a Starline brass casing. It also has brass primers, not silver primers. Special Prosecutor Morrissey proffered her conclusion, so I decided I agreed with Detective Hancock that this has no evidentiary value. The photo. The prosecutor offered additional conclusions about the Teskey supplied ammo, arguing, quote, there is absolutely nothing about the ammunition that Troy Teskey had that has any evidentiary value in the Gutierrez case. It has no evidentiary value in the Baldwin case. Finally, none of this is exculpatory at all. This is the exact same batch of ammo that had already been sent to the FBI and tested because it all came from the same place. There's no reason for us to do it again. After the argument, the court conducted an evidentiary hearing and ordered that the Teskey supplied ammo be produced for inspection, as well as the previously undisclosed supplemental report prepared in connection with the Sheriff's Department collection of the ammo. The first witness called was Popple. Before Popple gave testimony, the court reviewed the undisclosed supplemental report of crucial importance. Of crucial importance, the supplemental report documented that Popple collected from Troy Teskey, oh fucking hell, 3 Starline brass 45 Colt with silver in color priming, brass in color casing. Wow.
Bruh.
That's new information. In the supplemental case, in the supplemental report that the defense never got, it lines out that there are 3 Starline brass 45 Colt with silver color primers, brass color casing. Holy shit. Kari Morrissey argued to the court that this has no evidentiary value. Quote, that is not the same ammunition. You can tell from looking at it. This isn't a Starline brass casing. And it also has brass primers, not silver primers. Kari argues to the court dead ass. They are obviously different. And the report says that they are, in fact, Starline brass with a silver primer. No wonder the court was so mad. She could tell from looking at it. Further, the court asked Popple to identify the Teskey supplied ammo that fit this description. The court visually inspected the ammo. Yeah, the court got off the bench, put on the gloves, and looked at it. Thereafter, the court asked Popple, do you recognize any of these types of bullets to have been gathered on the Hannah Gutierrez on the Rust set? Popple responded, the Starline brass with silver primer are similar to what was collected on set. Directly contradictory to what was testified to in front of the jury the day before. The second and third witnesses called were Seth Kinney and Hancock. Both the state and defense asked Kinney questions regarding the ammo possessed by Troy Teskey and how some of that ammo was used during cowboy training camp for the production of 1883, and how the remaining ammo from that camp ended up at PDQ. Additionally, some of the defense questions sought to establish a progressive trail. Let's see. Establish a progressive trail to demonstrate the relevancy of the Teskey supplied ammo collected by the sheriffs. Specifically, defense question developed a timeline that A, 45 Colt ammo was once possessed by Troy Teskey. B, some of that ammo was then possessed by Seth Kinney and Thel Reed for use at training camp on 1883. C, Seth Kinney took the leftovers of the live ammo to PDQ. Seth Kinney then gave purported 45 Colt dummy rounds with brass casings and nickel or silver primers to Sarah Zachary on or about October 12th, 2021. Helena was shot on October 21st. E, Sarah Zachary then introduced these rounds onto the set of Rust before the October 21st incident. Could the ammo have come from PDQ? The prosecution has said over and over and over again that the only way live rounds got onto set was because Hannah got them from Thel Reed and brought them. But the testimony from Seth Kinney was that ammo from 1883, live rounds from 1883, went back to PDQ, and rounds from PDQ went to Sarah Zachary, went to set. So did the rounds come from Hannah, or did the rounds come from Seth Kinney, from Thel? Right? Such a wild difference from what was shown at Hannah's trial. That the only place these rounds could have come from were from Hannah. That was what the state said. They showed all the pictures of where it came from and how Hannah got them from her dad. But it could have also come from Seth. The reason this is different, give me a second. The reason this is different for Baldwin than it is for Hannah is that Hannah's defense attorney had this information. Hannah's defense attorney chose not to use this in trial with Troy Teskey. So Hannah has a much different argument than Baldwin. But as to Baldwin, part of Baldwin's defense was this is either sabotage or somebody else did it. But either way, the law enforcement just looked at Baldwin with blinders on. And Seth Kinney was never prosecuted. And they said, no live rounds came from Seth Kinney. Baldwin was arguing, yeah, they didn't even search his place till like a month and a half later. So yeah, there was nothing there then. The ammo can that came from 1883 was empty by the time y'all searched for it. And Seth Kinney gave Hancock shit about putting that in the search warrant. So doesn't that all support Baldwin's argument that everyone was laser focused on him and didn't do the rest of their investigation? Very different than the argument to Hannah. But as to Baldwin, oh boy. So, this is why the court is so mad. Regarding the direct examination of Hancock, the state elicited testimony concerning how the Teskey supplied ammo fit the investigation of the underlying incident, why those rounds were not initially collected, and why the supplemental report and collected ammo were not inventoried under the Rust case number. During cross-examination, Hancock testified that Popple gave false testimony during the second day of the jury trial. This is going to have an impact on everyone's career here. Absolutely. Specifically, Hancock testified that Popple's testimony given in front of the jury concerning the attributes of the collected Teskey ammo when compared to the attributes of the live ammo collected from the set of Rust was false. Spyro, do you remember the testimony that you were sitting here for? Hancock, yes, I do. Spyro. And it turns out to be completely false, doesn't it? Hancock, you're correct. Notably, Prosecutor Morrissey elicited this testimony through leading questions. That's not good for Morrissey. Further, because Morrissey elicited the testimony that the court said was false. Further, Hancock testified that once she became aware of Popple's collection of the Teskey ammo, Hancock, Morrissey, and the supervisors at the time discussed and resolved how to address the ammo, i.e., to inventory and associate the Teskey supplied ammo with a non-rust investigation case number. Look, you can put things under different case numbers. I cannot unbig myself. There we go. You can put things under different case numbers, but there has to be a connection between the two. So if things are inventoried under a different case number and there is a reason to do so, you say, hey, in a supplemental report to the main case file, hey, there is a related connected case number and it consists of this. And then, yes, it can live under a separate case number for whatever reason, but it's also noted in the main report. With no connection between the two, it is a huge problem and it seems absolutely shady as fuck. There has to be a report connecting the two case numbers. Has to be. So shady to not do it that way. Well, and this is the result. This is the result. You do it this way and your case gets dismissed. That's the result. Oh, I can't wait to hear what the court thinks of, oh, you guys, I can't wait to hear what the court thinks of Morrissey's testimony. Okay, we're getting there. We're getting there. All right. Everyone stay calm. We get to see what the court thinks. The fourth and fifth witnesses to testify were Brandel and Morrissey. Brandel's testimony concerned the circumstances of the collection of the ammo supplied by Teskey on March 6th. In addition, the court admitted video recording from Brandel's lapel camera, partially depicting the collection between Brandel, Popple, and Teskey. Special Prosecutor Morrissey provided testimony to the court concerning the Teskey supplied ammo and her understanding of its role with the Rust investigation. Oh, shit. However, Special Prosecutor Kari Morrissey's testimony was internally inconsistent in part and conflicted with testimony given by at least one other witness. The court is driving the bus and she's going to back it up right over Kari Morrissey. Oh boy. Oh boy. Judge Summer is fucking pissed. Oh boy. Oh boy. Oh boy. Okay, let's see what else the court has to say. Internally inconsistent. To have a judge say that you under oath gave internally inconsistent testimony is very, very bad. But Morrissey's not a career prosecutor. So what impact will this have? I guess we'll see. For instance, the court was just like, receipts, screenshots, transcripts, fucking everything. And I'm putting it in my written order. You know why? Because my verbal order was not strong enough. So I'm putting it in the fucking written order. You lied on the stand, written order. This witness said you lied on the stand, written order. The report said this in the written order, because the report we've never seen. They never talked about it. The court had it. All the parties had it. We never had it. The court is making a public record of all of the fuckery. Here the fuck you go. All right, Judge Summer, go off. For instance, Special Prosecutor Morrissey testified as to the Teskey supplied ammunition, quote, "So if it never left the state of Arizona, the only way that it is relevant to the Rust investigation is if it has any similarity to the live rounds that were found on the set of Rust." Because we were at that point trying to figure out the source of the live rounds. Yet, Morrissey also testified the rounds that were left at the sheriff's department by Teskey, I have absolutely no reason to believe that they are relevant to the incident that took place on the set of Rust. Those are rounds that were in possession of Thel Reed and never left the state of Arizona. I don't know if those are inconsistent, but she also said that she thought that Hannah got rounds from Thel. Further, during cross-examination, Morrissey, the defense asked, "You also did not allow the defense to view the Teskey supplied ammo evidence at any time during our request to review evidence in this case," to which Morrissey responded, "I had never seen it, and I didn't realize that it wasn't under the same case number because I'm not a law enforcement officer and I don't work at the sheriff's department, but you are right." However, this testimony conflicts with that of Corporal Hancock. Oh, danger! Danger. This testimony conflicts with Corporal Hancock, who testified that the sheriff's agents and special prosecutor decided to separately file this evidence from the evidence in the Rust investigation. Additionally, Morrissey acknowledged that Popple provided false testimony before the jury on July 11th, and she's going to name it. Spyro, quote, "Yesterday when Popple testified, you would agree with me that her testimony under oath was false." Morrissey, what part of her testimony was false? And I'll answer. Spyro, that she said that the rounds don't look anything like the rounds on the set when you elicited that testimony. Morrissey, I agree with you. I didn't realize that there were rounds that looked like that. It's in the report. It's in the supplemental report. The supplemental report says that they are Starline brass with silver primers. Ma'am, did you also not read the report? Did you never read the report? Somebody walks into the sheriff's department the day of your closing argument and was like, "I have ammo related to your very high profile case." And you never read the report? Okay. After the conclusion of the evidentiary hearing, the court granted the defendant's motion. Analysis and ruling. Overview of the law pertaining to Brady violations. I am not going to break down the court's entire analysis of the law, but I will put the link to this in the app if you guys want access to this document. We can also put it in the description of the case. I will link the document from the court's website if you guys want it. Overview of the law pertaining to Brady violations. And we're not going through all of it. Overview of the law pertaining to discovery violations. The court's like, "This is why I'm right." Brady analysis. The court's like, "And further, this is why I'm right." Harper analysis. The court again saying, "Under the law, I'm right, I'm right." Let's see. Given the court's assessment of culpability and prejudice, the court concludes that the extraordinary sanction of dismissal with prejudice is justified under the rubric of Harper with the additional guidance of Lemaire. I probably pronounced that wrong, but I'm going with the pronunciation like the skincare brand. It's not a simple choice easily resolved by reference to some basic judicial arithmetic. The question requires our courts to navigate an array of concerns and exercise their discretionary power with practical wisdom and due care. Dismissal with prejudice is appropriate for several reasons. Several reasons. First, the state repeatedly failed to fulfill its discovery obligations during pretrial litigation of this case. Second, the state's suppression of the Tuskegee supplied ammo and related evidence constitutes willful and deliberate misconduct. Whew. Third, Special Prosecutor Morrissey elicited false testimony from CST Popple on July 11th in the presence of the jury. That is going to have quite a lot of impact down the road. The court got madder over time because the court said this was close to bad faith. The court is now calling it willful and deliberate and said that the special prosecutor elicited false testimony. Fourth, a mistrial in this case would not only be based upon manifest necessity and jeopardy had attached well before information concerning the non-disclosure came to light. Here, a mistrial would be based solely on the state's discovery violations. In this circumstance, a sua sponte declaration of mistrial is improper. And then the court goes through why. The court says lesser sanctions are inappropriate. The court says, I have the power. The state's discovery violations injected a needless, incurable delay into the jury trial. Further, the state elicited false testimony from a state's witness. Dismissal with prejudice pursuant to the court's inherent power is additionally warranted to ensure the integrity of the judicial system and the effective administration of justice. By the time the court gets to hearing on the co-defendant cases, the court's not going to be less mad. The reason I wanted to go over this dismissal with y'all is because the court is pissed, and it gives a lot of context to what's going to happen in Gutierrez. The court's order, the written order in the Baldwin dismissal, is absolutely scathing. And the court not only talks about the late discovery that was rampant in the case, the late discovery of the Tuskegee ammo, but directly states more than once that the court finds that Special Prosecutor Kari Morrissey elicited false testimony from witness Popple, the crime scene technician, who said that the Tuskegee supplied rounds that they had in evidence under a separate case number did not match anything on the set of Rust. And that was not true. The court gave a very thorough but scathing indictment of the behavior of both the my brain just stopped because my brain was like, San Fernando? No, Emily, we're not in California. Of the Santa Fe Sheriff's Department and Special Prosecutor Morrissey's actions. Erlinda Johnson is mentioned once and briefly in this ruling as trying to remedy some of the discovery issues, and that is it. The impact of Erlinda walking off is seen very much in this court's order, and the reason is more clear. Because the court states for the first time that we're learning about that in that supplemental report buried under another case number, it clearly describes that 3 of the rounds taken by the Sheriff's Department from Tuskegee the day of closing arguments and conviction of Hannah Gutierrez matched things that were recovered, matched ammo that was recovered off the set of Rust. And the court lines out how that ammo went to Seth Kinney and could have gone to Sarah Zachary and ended up on the set of Rust. So it now gives 2 options for how live rounds ended up on the set of Rust. This ruling indicates to me that this judge is absolutely horrified and outraged by what happened here, and noted specifically the prosecution's eliciting of false testimony during trial. And that's part of why the court dismissed the case against Baldwin mid-trial. So the reason Erlinda was so mad comes even more into focus with now knowing that that supplemental report was clear as day. Just clear as day. And of course, there are ongoing motions in the Hannah Gutierrez case, which we are going to get to now. Kari Morrissey is still the special prosecutor on Hannah Gutierrez's case. The DA's office, before this order came out, and this order came out, what is the date on this? Hold on. Where's the stamp? 3 seconds. Oh, that's probably more than 3. This order came out July 31st. Prior to this court order coming out, Kari Morrissey was still the special prosecutor on the Hannah Gutierrez case. And the DA's office had said, Kari Morrissey stays on this case. Will anything change after the court's scathing order in the Baldwin case? Maybe, maybe not. But for now, Kari Morrissey on the same day, July 31st, filed her response to the defense motion from Hannah Gutierrez for new trial. She got permission to go over page length, and so it is a very long, by the looks of it, motion. I have not gone over it yet, but when we saw the response to the request for immediate release, it was met with quite a lot of snark and throwing Baldwin under the bus. Kari Morrissey's motion was filed the same day this order came out from the court. So Kari Morrissey does not have hindsight on how the judge is feeling about her when she wrote the motion that we're about to read together. So will it be as snarky? I wonder. But what we've covered already is Kari Morrissey's responses to the defense request for immediate dismissal of Hannah Gutierrez. Hey, Your Honor, you've got to let her out. She's in custody. She's in prison for 18 months. Let her out immediately. And the DA said, well, it's premature to ask for this. This is the wrong process. And how we have to address the motion for new trial before we ever get into whether or not Hannah gets released. Keep in mind that the arguments in Hannah's case are very different because Troy Teske went to Hannah's lawyer first. Hannah's lawyer saw the rounds that Troy Teske had. So Hannah's lawyer knew. Baldwin's lawyer didn't. And that's why these cases might go differently. But I think the court is going to hold the prosecution with a very, very tight leash on this and not give them the benefit of the doubt at all. I think Kari Morrissey has lost credibility in the eyes of the judge, and that is my opinion, based on reading that last ruling. So Morrissey is not going to get a pass on anything, which means when this goes to oral argument on these motions, it is going to be spicy. Am I here for it? Yep. Yep, I am. Absolutely am. So, are we ready? All right, let me pull up her response that excessively exceeds page limits. The court allowed her to do so. Am I thrilled by this? Sure. More pages of snark. Kari Morrissey's motion is 42 pages long. Well, her opposition is 42 pages long. So let's do that together and see how much snark. It's going to be real interesting after reading what the judge just had to say, isn't it? And we're going to read it together. Filed July 31st at 10:38 p.m. Talk about hitting the deadline. Hitting the deadline exactly. State's response to defendant's motion for new trial. Facts relevant to defendant's motion. Defendant Gutierrez seems to complain of 4 issues. Oh, good God. We're already starting with the, Your Honor. Who even knows what he's saying anyway, Your Honor? He's just like throwing a bunch of shit out there and it's not clear. Your Honor, it's not clear. Defendant Gutierrez seems to complain of 4 issues that she alleges support her motion for new trial. First, She generally argues that undersigned counsel lied under oath during a motion hearing during the trial against Mr. Baldwin and failed to disclose the existence of ammunition that was obtained from her father's close friend, Troy Teskey, in March 2024. The court found Morrissey inconsistent, but said that she elicited false testimony and not specifically saying she lied under oath. She said that she was inconsistent. And I think that's because the court doesn't know who's telling the truth. Second, defendant raises concerns regarding an audio recording interview of Seth Kinney that was not disclosed until after her trial concluded. I hate that. I do not like that at all. Third, Gutierrez asserts that she should be granted a new trial because the supplemental report produced by Lucian Hague August 31st was not provided to her or her counsel prior to trial. Fourth, Gutierrez asserts that she should be granted a new trial because there are unremarkable email communications between state's experts Hague and Brian Carpenter that were not disclosed to the defense prior to trial. Undersigned counsel did not lie under oath. Undersigned counsel testified that she was aware that Mr. Teskey provided ammunition to the sheriff's department at the end of the Gutierrez trial. Undersigned counsel further testified that she was not aware that the doc report outlining the fact that the ammunition had been provided to the sheriff's department did not contain the same case number or would not be linked to the same case number as the rest of the evidence related to the Rust investigation. This was a true statement, and undersigned counsel qualified her statement during cross-examination by explaining that she misunderstood that the doc report would have a different case number assigned because she is, quote, not a law enforcement officer and doesn't work for the sheriff's department. She goes on to say Corporal Hancock understood that the new doc report would have a different case number because it was a separate doc report. Underside counsel did not understand that doc reports have different case numbers due to her lack of familiarity with the manner in which case numbers are assigned at the sheriff's department. Undersigned counsel and Corporal Hancock testified truthfully. So she's saying two things are true I didn't know. And that's why the court said it was inconsistent, because I don't think the court knows who's accurate, because we didn't get into this line of questioning that much. Is it accurate that Kari, Morrissey, Hancock, and everybody else said, okay, well, we'll just put it under a doc report instead of a supplemental report? And Morrissey was like, yeah, whatever, fine, and didn't know or not. So I think that's why the court called this inconsistent. But it doesn't, for Baldwin, it doesn't matter, because if it's in evidence, she has to understand it. Morrissey goes on to say that she testified truthfully when asked why Erlinda Johnson withdrew from the case during the motion hearing. Babe, what are we doing? Do not bring Erlinda into this. Ma'am, keep Erlinda's name out of your motherfucking mouth in this motion right now. What are we doing? Ooh, chat. I don't like it. I don't like it. I don't like it. I don't like it at all. I don't like it at all. I think we're code red. I think we're code red on that. What do you think, chat? I'm feeling red. Like, I'm just like, no. 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 Yeah, I'm feeling code red. I'm feeling code red just because we've gone beyond audacity to actual what the fuck. And I haven't even finished hearing what she has to say, but I am red. I immediately went, no. If any of you are new to the chat, now's a very good time for me to mention to do the YouTube-y things, like the video, subscribe to the channel, join as a member, download the app, all the YouTube-y things. The app is now part of the YouTube-y things. So we've got that defined. Second, we're going to code red. If you are new, code red is flashy. It ends the flashy when the music ends. So if you are flash sensitive, it is 8 seconds long. The flash ends when the music ends. So this is your heads up. We are going to code red in 3, 2, 1. This is our DEF CON level WTF. We had a whole DEF CON rating system during other filings, but we ended up with like WTF, bruh, and Audacity. So that is our code system. Code bruh, code Audacity, and code WTF. Occasionally we will get to code Fred when my cat tries to disconnect my technology. It's been a minute. But we're at code red. Undersigned counsel testified truthfully when asked why Ms. Johnson withdrew from the case during the motion hearing. Please explain. Prior to the lunch break on July 12th, without hearing any of the testimony or argument related to defendant's Baldwin motion to dismiss, the court went off the record and notified undersigned counsel and Spiro that she was intending to dismiss the case. What? What? That's new information. Prior to the lunch break on July 12th, without hearing any of the testimony or argument related to defendant Baldwin's motion to dismiss, the court went off the record and notified undersigned counsel and Spiro that she intended to dismiss the case. This is why the court was like, Miss Morrissey, you don't need to testify. The court tried to stop her. This is why the court was like, I already told you where this is going. Before lunch. That's why. That's why Baldwin and his wife were sitting there like petting each other in court. Because we knew Baldwin looked happy. His wife looked relieved. They were sitting in court like this with each other. And now we know why, because the court told Spiro, who told Baldwin, that the court is going to dismiss it. That makes everything make more sense. They knew. Oh my fucking God. I didn't know how code red we'd need to be because I didn't read ahead. Oh my God. Now we know why Baldwin and his wife were so happy. Because the court said that she was inclined to dismiss the case at lunch. Also, I'm just going to take a moment to toot. Hold on. Because I felt, not y'all, the Lawnards that are here are the ride or die Lawnard OGs. But the amount of time I spent fighting with chat, and it's rare, saying they are not working out a plea deal over lunch. That's not what's happening. We're going to wait till after lunch to see what's going on. We are waiting for facts. We are not speculating. This is why. The reason they were so happy is not because they were working out a plea. It's because the court already said, I am inclined to dismiss this case. Because she saw the bullets. So, do I often come on here and toot my own horn about I was fucking right? No, I don't. Most of the time I let it go. But I'm not letting this one go. Why? Because I was right. I was right. This is why we wait. Waiting sucks. I also hate it. I am not patient. But when it comes to court, we will figure it out. Things will be known. It just sometimes takes a little bit of time to bubble up to the surface. And that's why we do not lean in to the rumors, unless it's Housewives. We'll lean in a little bit in Housewives. The speculation, the gossip, the nastiness. In court, we wait. We wait and see. We had to put up a whole special bumper saying, please stop speculating. Because we waited. And now we know at lunch that the court had told, I feel like we're in Titanic. They had the report in their hand of icebergs, and they're still going full steam of fucking head. She knew, Kari Morrissey fucking knew. She knew that the judge was inclined to dismiss the case and got on the stand anyway. Are you kidding me? Oh my God. It's so crazy. It's so crazy. It's so crazy. Oh. She had the courts indicated, and the court said again, you don't have to do this. And she did it anyway. She's like, I'm going to clear my name. Well, Kari, that's not exactly what happened, is it? Oh my God. Okay, so prior to the lunch break on July 12th, without hearing any of the testimony or argument related to Defendant Baldwin's motion to dismiss, the court went off record and notified counsel and defense counsel she was intending to dismiss the case. Underside counsel and Johnson discussed the issue at great length over the lunch hour. Based on the court's off-the-record statement, it was apparent that the court was intending to dismiss the case. The state had two choices: dismiss the case of its own volition, or have a full hearing, develop a record, and let the court dismiss the case. Ms. Johnson wanted the state to dismiss the case and stated that she wanted the case dismissed out of concerns for self-preservation. You are not throwing Erlinda under the bus. Oh. Wow. Erlinda was like, no. I hope Erlinda responds to this. But what Erlinda said in all of her statements is once it came out that stuff wasn't disclosed and there was a Brady violation, which there was, you have to dismiss the case. That's the ethical obligation. Oh, the fucking audacity.
Bruh.
On the heels of the court being like, counsel elicited false testimony. She's like, but Your Honor, Erlinda had concerns for self-preservation. I did the righteous thing here. No. Erlinda, come get your girl. Either that or come chat with me. Erlinda, come chat with me. Let's have a chat. Because the fuck? Undersigned counsel disagreed that self-preservation was an appropriate reason to dismiss a homicide case, but a Brady violation is. I'm so mad. Disagreed that a dismissal was warranted under the circumstances and proceeded to a full hearing. That's accurate. Kari disagreed that a dismissal was warranted under the circumstances. That's true. That's exactly what she thought. Erlinda was right. Erlinda said, no, a Brady violation, dismiss. And Kari's like, no, don't dismiss. Erlinda didn't disagree with having a public hearing, which was Kari's testimony. Why do I remember that? Because we watched it back like 4 times. Kari said Erlinda left because she disagreed with having a public hearing. That's not what she disagreed with. She disagreed with the hearing continuing and thought the prosecution should have dismissed the case. It leaves the wrong impression, Kari. Ms. Johnson did not want a public hearing out of concerns for self-preservation, and undersigned counsel testified truthfully in this regard. We're going to get Erlinda filing a supplemental being like, for the record, I believed that it was the ethical obligations of the prosecutor to dismiss the case when the Brady violation became clear. So I said that that was the only appropriate thing to do. And Kari said no. So this is not, Miss Johnson did not want a public hearing. I'm not with you on this one, Kari. Underside counsel has not had a win at all costs attitude in the Rust case. In fact, it has been the opposite, and Mr. Bowles knows it. Ma'am, the court found that you elicited false testimony from a witness, though. I don't know how well taken this is going to be. Undersigned counsel attempted to resolve Miss Gutierrez's case with an agreement. Oh, girl. And now she's just going to throw everyone the fuck under the bus. The problem is that this prosecutor, special prosecutor, has miscalculated who's driving the bus. The judge is. In fact, it has been the opposite, and Mr. Bowles knows it. Undersigned counsel attempted to resolve Miss Gutierrez's case with an agreement that would have prevented her from being incarcerated and prevented her from becoming a convicted felon. You can't use plea negotiations against the defendant. Also, taking... no. Just no. And now she's trying to be like, Bowles, you fucked up. Your client wouldn't be in prison without you. Presumably, upon the advice of her trial counsel, she declined the plea offer, as is her right. Bringing up the plea negotiations at this point is disingenuous and gross. Underside counsel then went so far as to file a sealed motion asking the court to counsel Miss Gutierrez. You're going to just talk about sealed motions now? Kari is burning the boats while she's standing in them. Normally, you get out of the boat before you light it on fire. Well, I guess we're spilling all the tea today. Oh my God. Me, I'm not reading all of this motion. Me, the tea is scalding hot. She is throwing Bowles under all of the things. I don't have an analogy. I'm stunned. I am of two minds. Lawyer me is fucking appalled. You're not putting in sealed argument and putting in plea negotiations. At this point, it's just gross and inappropriate. Streamer Emily is like all of the tea. All of the tea spilled. And it is fucking scalding. Streamer Emily wants to know everything. Lawyer Emily is like, what are you doing? So I am of two minds, chat. So I am just stunned. Kari is screaming Dracarys while holding, kerosene in a match. Emily, don't bring the interrupters into this. They would never. You're right. They wouldn't. Okay. Let's get to Kari throwing Bowles under the bus. It really is like a drowning human that is just trying to grab onto anything they can and take it down with them. Presumably upon the advice of her trial counsel, she declined the plea offer, as is her right. Undersigned counsel then went so far as to file a sealed motion asking the court to counsel Ms. Gutierrez with regard to the plea offer on the record to ensure that her refusal to accept the offer was knowing, intelligent, and voluntary. You do not go spilling the tea on sealed court documents. But she's doing it to lash out at Bowles. That's not... This court is already unhappy This is not going to make it better at all. The court declined to put the plea offer on the record and ensure that Ms. Gutierrez understood the consequences of her decision. Similarly, undersigned counsel offered a plea to a misdemeanor to Mr. Baldwin, but rescinded the plea offer when further information surfaced regarding Baldwin's conduct with material witnesses to the case. This is hardly a win at all cost attitude. So your feelings are hurt. So you're going to disclose the content of sealed documents, off the record conversations, and your plea negotiations in one paragraph. Okay. We're only on page 3. Undersigned counsel testified truthfully with regard. Oh, and Erlinda went right onto that bus too. Undersigned counsel testified truthfully with regard to the termination of previous paralegal assigned to the Rust case. You've just chosen to name him and shame him, apparently. Mr. Taub's work was unsatisfactory, and a decision was made that his work would cease after the conclusion of the Gutierrez trial. Oh, Kari, tell us what happened. Tell us what happened with Bouillon. If we're spilling all the tea in an unprofessional and inappropriate way, can you tell us what happened with Bouillon too? Because I'm fascinated and I really want to know. Undersigned counsel stopped assigning him tasks due to the poor quality of his work, and this resulted in his effective termination. I mean, that's not an effective termination if you stopped assigning him work. That's just, he's not working with you. The paralegal complained about working conditions as they related to another employee at the DA's office who he had difficulty getting along with, but he never complained about the undersigned counsel until he complained that she was no longer assigning him tasks. See Exhibit 1. Okay. It should be noted that Bowles made mention of emails of an affidavit concerning the issue of the termination, but attached none as exhibits to his motion. Undersigned counsel will move to strike or in the alternative request leave to submit supplemental briefing should Bowles decide to submit email affidavits or exhibits to his reply. So now we're fighting over the paralegal and why the paralegal quit. It has nothing to fucking do with this motion for new trial, but I'm just, okay, T. Oh yeah, full Bethany. Mention it all. This is some housewife shit happening. I need to watch New Jersey. Undersigned counsel testified truthfully that Mr. Bowles did not want the Teskey rounds. During the brief statement Mr. Teskey made when providing the ammunition to the sheriff's department, he stated that he was asked by defense counsel to testify on Gutierrez's behalf and bring the ammunition in his possession to the Gutierrez trial. How does Kari know that if she knew nothing else about this ammo, though? Did you learn it that day? Teskey did as he was asked, and Mr. Bowles decided not to call him as a witness and not to use the ammunition Bowles asked him to bring from Arizona. Teskey specifically stated that in his brief statement to law enforcement that Gutierrez's counsel didn't want the evidence he brought from Arizona. It is stunning that Mr. Bowles now claims that his client was somehow prejudiced by the state's failure to disclose ammunition that was not in the state's possession, but was in the possession of a defense witness and was available to counsel. Yeah, I think it's their weakest argument. A recorded interview of Seth Kinney, way more persuasive to me. The photographs depicted 4 rounds. Let's see, wait. Mr. Bowles provided these photos to undersigned counsel. Oh, I went too far. Apologies, chat. The January 8th, 2024 email referenced by Bowles had 4 photos of the Teskey ammo. Bowles provided these photos to the undersigned counsel. The photos depicted 4 rounds that had brass primers. Only one had a Starline brass casing, and all had projectiles dissimilar to the rounds found on the set of Rust. Bowles is the person who provided undersigned counsel with the information that caused her to abandon any effort to obtain or test the rounds. The only information underside counsel had about the Teskey rounds was the information provided by Bowles and Teskey, and all of the information was that the rounds in Teskey's possession were dissimilar to the rounds from the set of Rust. On November 1st, 2021, just 1 week after Miss Hutchins' death, Teskey had the following text exchange with Kinney, wherein he provided Kinney with a photo of all of the, quote, different types of ammo that he could find in the .45 caliber ammo he stored for Reed. Now, the black and whites, not helpful. Those might have been submitted to the court in color, but the black and white's not helpful for our purposes. The photo depicted 4 rounds, one with a Starline brass casing and brass primer, one with a CBC casing and brass primer, one with a Winchester casing and a brass primer, and one with a BHA casing and brass primer. But you said that none of them had Starline casings. Also, these have to come from Seth Kinney's phone. And is Seth Kinney really referring to Teskey as da fuzz? I'm guessing so. The photo does not show the projectile size shape, but all are clearly dissimilar to the live rounds from the set of Rust, which all had Starline brass casings with silver or nickel primers. I can't see shit in those photos, other than apparently Teskey is referred to as da fuzz because he is a former cop. I checked a bunch of the rounds. These are the 4 different types that I could find. 2 years later, in November 2023, Teskey's pretrial interview was conducted as he was being called as a defense witness at the Gutierrez trial. During this interview, undersigned counsel again inquired of the ammunition and considered taking steps to obtain ammunition from Teskey, but had difficulty determining if it was material evidence. On January 8th, 24, Bowles provided the following pictures to counsel and asked if she would send the rounds to FBI for testing. These all look different than the photos we saw in court, by the way, which had it being held in somebody's hands. These photos provided by Bowles on January 8th, 24 show the exact rounds that were photographed and sent to Seth Kinney on November 1st. Which is impossible to tell because they're all black and white and blurry, but the court hopefully will have better photos. Only in the photo on page 6, the truncated cone projection can be seen, confirming that the rounds are highly dissimilar to the live rounds found on the set of Rust. The rounds are comprised of 4 rounds, one with Starline brass casing and brass primer, one with CBC. Those are the same. I'm not going to read it again. As of January 8th, Teskey was in possession of .45 caliber rounds belonging to Reed, none of which were similar in size and shape to the rounds found on the set of Rust. The live rounds from Rust are pictured below. So again, she's talking about the shape of the coning. To be clear, the ammunition in Teskey's possession was owned by Thel Reed, Gutierrez's father. There is no evidence that they ever left the state of Arizona until Teskey brought them to New Mexico at Bowles' request during the trial. Well, there is some indication because in the court's order, the court said that some of that ammo went from Teskey to Thel to 1883, back to Seth Kinney, back to PDQ, and some of it stayed in Arizona or went back to Arizona from 1883. So some of it went to 1883, not in Arizona, because I thought 1883 cowboy camp was in Texas. But she's saying there's no evidence that it ever left the state of Arizona until Teskey brought it to New Mexico. They were not provided to law enforcement or anyone on the prosecution team until the end of Gutierrez's trial. The rounds were not in the state's possession until March 6th. On November 3rd, Kinney asked Teskey if he located any rounds with silver primers, and Teskey responded No. The first time underside counsel became aware that Teskey was in possession of rounds that looked similar to the rounds in Rust was the morning of July 12, 24, because she was under the mistaken impression that the rounds received by the sheriff's department in March were the same as the photos provided in November 2021 and January 2024. Kari goes on to say, it is highly suspect that Teskey provided photos of rounds in November 21 and January 24 of rounds that are completely dissimilar to live rounds found on the set of Rust, confirmed in writing in November 2021 that he was unable to locate any rounds with silver primers, and then on March 6th, he dropped off rounds similar to those on Rust. It is a bit sus. But you know what? You ask him about it on cross-examination. You still have to turn it over to Baldwin's lawyers. It's a different question as to Hannah's lawyers. I don't think this is Hannah's best argument because this was a defense witness for Hannah and they knew. This is not their best argument. The Seth Kinney interview, better. This is very strong as to Baldwin, but that's already been dismissed. Oh my goodness. I can't tell what date this is. This looks like the same November texts from 2021. I checked a bunch of the rounds. These are the 4 different types that I could find. Yep, it's evidence in the accidental death. Don't get me started on Seth Kinney. I'll never stop. Because Seth Kinney just being like, it's evidence. Who are you? Seth Kinney is, the man inserted himself into this investigation so fucking much. He's like, that's evidence. What, you're the investigator now? Yep, that's evidence in the accidental death. Yep. Okay. This sucks because she's seriously trying to blame everyone else for her mistake. Who is she? Hannah? ? Hannah, says Seth. November 3rd, 2021. Did you see any rounds in either box with nickel primers? No. Thumbs up. Okay, but that's limited to 2 boxes. The ammunition was never in possession of Seth Kinney or any other witness listed on the state or defendant's witness list in the Baldwin case, other than presumably or possibly Ms. Gutierrez herself, but the court was unwilling to compel her testimony. Okay. Undersigned counsel is still struggling to understand how ammunition that was never in possession. I mean, you're saying the quiet part, Kari. I'm going to start that sentence over because undersigned counsel is still struggling to understand how ammunition that was never in possession of, seen by, or known to any witness being called to the trial and was turned over 2.5 years after the death of Ms. Hutchins created a discovery violation that justified a dismissal with prejudice of Baldwin's case. The court just told you, though. It wasn't just that, though. But wait, there's more. Kari's like, I don't understand. I still don't see the big deal. Your Honor, what's the problem? Your Honor, why is this an issue? This ammo never left. Well, remember, this was filed the same day that the court filed their ruling. Of the rounds, she goes on to say, turned over by Teskey, all belonged to Thel Reed, and 3 appeared similar to the live rounds on the set of Rust. Again, there is no evidence that any of these rounds were in possession of Mr. Kinney, the court disagrees, or anyone other than Mr. Reed. Well, the thing is, ammo like it could have been in Kinney's possession from 1883. That's the thing. Ms. Gutierrez stated during her second interview with Corporal Hancock in November 21 that she sourced her dummy rounds from her father. This evidence does not support a sabotage theory. It supports what the state has asserted all along. Gutierrez brought the live rounds onto the set of Rust after obtaining them from her father, Thel. Moreover, if we assume that the live rounds found on the set of Rust were planted there by a saboteur, even though they appear identical to Thel Reed's rounds produced by Troy Teskey, it is still Gutierrez's job to inspect the rounds to ensure that all rounds put in the gun for the rehearsal were inert. I agree with that point. That's one of the only things I agree with so far, but I agree with that point. The argument regarding these Teskey rounds as to Hannah Gutierrez is not as significant as it is to Baldwin, because the defense had access to these. The defense knew about them. It doesn't change what happened in Baldwin at all, but it does change the argument for Hannah. The defense knew about them, chose not to call the witness, and Hannah had to inspect each round. So how the rounds got onto set are less important to Hannah's cases and arguments. So she goes on to argue, Hannah still failed this simple task and it resulted in someone's death. For this failure, she was tried and convicted. As discussed on July 12th at the Baldwin motion hearing, Gutierrez photographed herself in possession of live rounds on or about November 30th, 2021. She sent photos to her attorney and they were later discussed in text messages that included Mr. Reed, thus breaking any privilege that may have existed despite Gutierrez's full waiver of privilege with regard to her cell phone extraction. These photos make the Teskey rounds even more inculpatory and not exculpatory. These are Hannah's photos. And this came up in the court's hearing. These photos were taken 5 weeks after the death of Hutchins and were of live rounds as described in text messages between Bowles, Reed, and Gutierrez. Thel Reed. These rounds appear to match the live rounds found on the set of Rust. Undersigned counsel intended to use these photos during the Gutierrez trial if Gutierrez testified, but she did not. These photos further demonstrate that the live rounds in Teskey's possession are relevant to Gutierrez's culpability if they are relevant of anything at all. Kari goes on to say, it's worth noting that sending ammunition to the FBI. Oh, that was too low. For testing is not determinative of whether they are the same as the ammunition from the set of Rust. All the FBI can determine is whether the powder used is the same. But that same type of powder is used to make millions of cartridges every year by countless different manufacturers. And then we get into the testimony from the expert from the FBI. On page 6 of her motion for a new trial, Gutierrez stated as follows, quote, this court stated on July 12th that the integrity of the judicial system demanded that the court dismiss Mr. Baldwin's case with prejudice. How can it be any different with Miss Gutierrez Reed's case with this proven litany of serious discovery abuses? The intentional withholding of crucial evidence, Brady and Giglio, by the state has compromised the integrity of the entire judicial process. The answer to Mr. Bowles' question is where my brain went, but that's not what's written. The answer to Ms. Gutierrez's question is twofold. First, the question assumes that the court properly dismissed the case against Baldwin. Oh, dear. Oh, dear. No, no, no. Oh, no, 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 no. First, the question assumes that the court properly dismissed the case against Baldwin. Although the court's final order has not yet been filed, underside counsel contends that the court misunderstood the testimony on July 12th and improperly dismissed the case against Baldwin. Chat. How glad are we that we went over the court's ruling first? How glad are we went over it first? I'm so glad. I'm so glad that we did that one first. I am so glad because, oh boy. Undersigned counsel contends that the court misunderstood the testimony on July 12th and improperly dismissed the case against Baldwin.
Bruh.
For the case against Baldwin to be properly dismissed for a Brady violation, the court needed to find the following. The evidence at issue must be favorable to the accused, either because it is exculpatory or because it is impeaching. That evidence must have been suppressed by the state either willfully or inadvertently, and prejudice must have ensued. Mr. Baldwin was charged with violating all rules promulgated to ensure firearm safety by actors on movie sets by pointing his gun at two people during a rehearsal, not filming, cocking his gun when the rehearsal did not call for that action, and pulling the trigger when the rehearsal did not call for that action. The case was dismissed due to the state's failure to disclose the ammunition dropped off at the sheriff's department by Troy Teske on March 6th to Baldwin's defense counsel, and more. The Teske ammunition was provided 2.5 years after the shooting of Miss Hutchins, and there's no evidence that the ammunition was ever possessed by, seen by, or known to any witness being called by the state or defense. She's continuing to fight the Baldwin case in this motion. There is no evidence that Mr. Kenny ever possessed or knew of the Teske rounds There was no evidence that Mr. Kenny ever possessed or knew of the Teske rounds that appear similar to the live rounds on the set of Rust. Okay. The evidence is not exculpatory as it has nothing to do with the basis of the charges against Baldwin, and it's not impeaching as to Mr. Kenny or any other witness never possessed it or had knowledge of it. It might be impeaching as to Kenny based on how Kenny got evidence or rounds from Thel Reed and then gave them to Sarah Zachary. It's also impeaching to Popple because Popple testified that they weren't the same. Wrong. So it's not just, it's impeaching to Popple too. The state concedes that it was suppressed from the defense because law enforcement was unable to develop any evidence that established the relevancy of the ammunition to Hutchins's death due to Teske's unwillingness to provide an interview to law enforcement. Then you turn it over and argue that the defense can't use it. The audacity. The state further contends that Mr. Baldwin suffered no prejudice as a result of the suppression of the Teske ammunition due to lack of connection of the ammo to Mr. Kenny and the fact that Baldwin's defense team was well aware of the Teske ammunition prior to trial because they suddenly canceled all evidence viewing, or they suddenly canceled an evidence viewing in mid-June 2024 and cross-examined Popple at great length regarding the Teske ammunition. Okay. Second, if the court were to decide that the dismissal of the case against Mr. Baldwin was proper, all right. There is a huge difference, all caps, in the Gutierrez case. The state was not in possession of the Teske ammo prior to trial, although arguably Mr. Bowles was. I agree with that. That thing. I agree with that. In the Baldwin case, the state was in possession of the Teske ammunition. Mr. Bowles is comparing apple to oranges by trying to make a square, pick an analogy and go with it, by trying to make a square peg fit in a round hole. This is more interesting to me. The undisclosed evidence with regard to an interview of Seth Kinney. This is much more interesting to me. I think Kari is, with limitation, correct that because the defense was aware of the Teske evidence and chose to use it or not use it, that it's not Brady as to them. But when Mr. Kenny submitted to a pretrial, the judge's head, can you imagine the judge has just turned into the mind blown emoji, learning that there is a another witness interview that wasn't turned over after the way the judge laid out the case in their order. When Mr. Kenny submitted to a pretrial interview with Mr. Baldwin's counsel on April 1st, he stated that shortly after the search of the prop truck at Bonanza Creek Ranch on October 27, 21, he met with investigators at the DA's office and provided a recorded statement. Undersigned counsel was unaware that Kenny had such a meeting after his pretrial interview. I read that awkwardly. Counsel was unaware Kenny had such a meeting. I'm going to take a moment to remind everybody. If the DA's office has done something, interviewed someone, has reports, or law enforcement does, the law says that everyone knows on that team. So Kari being aware or unaware is irrelevant to all of this, other than to say it was unintentional, perhaps. Like, Your Honor, I didn't know. It doesn't fix it, though. It's your job to know. You don't get a, whoopsie, mulligan because you didn't know. If your office did it, you did it. Does that make sense? Hopefully that clarifies. You have institutional knowledge, even if you don't have actual knowledge. Undersigned counsel was unaware that Mr. Kenny had such a meeting, and after his pretrial interview on April 1st, she immediately reached out to investigators at the DA's office, and they confirmed that a recording of the statement existed. Counsel requested a copy be provided to her immediately, and she subsequently shared it with defense counsel for Baldwin and Gutierrez. That's a month after Hannah was convicted. Undersigned counsel was unaware of the recorded statement made by Mr. Kenny when he met with investigators at the DA's office and therefore failed to provide the recording to defense counsel. That's a huge fucking problem. You tell me if you think that Seth Kenny was a great witness for the state. Personal opinion, he came across shady as hell to me. I don't like the way he testified. It was schmarmy. I did not like Seth Kenny's testimony. I don't like that he wasn't investigated more thoroughly. It did not sit well with me. And the defense could have impeached him differently depending on what's on this recording. Seth Kenny is a very impeachable witness. I hate all of this. Undersigned counsel was aware of the recorded statement made by Mr. Kenny when he was unaware of it, and didn't know. Let's see. I'm going to read that again because I read it weird. Because she admits that they didn't turn it over. This recorded statement was from 2021. And she turns it over a month after Hannah's convicted. What are you doing? And the way the court laid it out, that live round could have come from Seth Kenny. We just covered it in the court's order. Ugh. Undersigned counsel requested that a copy be provided to her immediately, and she shared it with counsel for Baldwin and Gutierrez. Counsel was unaware of the recorded statement made by Kenny when he met with investigators at the DA's office and therefore failed to provide the recording. It's impeachment. Or it could be impeachment. I guess without knowing what's on the recording, I can't say that it's impeachment. It could be impeachment. However, she's saying Kenny's statement was cumulative and is consistent with the text messages between Kenny, Zachary, and Gutierrez. All of the messages were provided to the defense. Kenny's statement is also consistent with the testimony of other witnesses that testified at the trial and were interviewed by Mr. Bowles. Mr. Bowles points to 20 statements in Kenny's interview that he claims justify a new trial. If it's impeachment, it gets you a lot further. That is why she's arguing that this is cumulative, it's consistent, and it's not impeachment. Statement number 1. Oh, we're going to go through all of them. Okay. Statement number 1, Mr. Kinney's statement about the hierarchical relationship between Zachary and Gutierrez is consistent with statements made to law enforcement by Zachary and Gutierrez and is consistent with Kenny's text messages. But if he didn't say it in any of the other recordings, is it inconsistent with his testimony? Because if it's inconsistent with his testimony, it's a problem. This is not going to go well. All of this evidence, except for the recorded statement, all of this evidence had been in the possession of Mr. Bowles since his client was initially charged. Except for the interview. This is not new evidence, and if Mr. Bowles wanted clarification about Zachary's supervisor role from Kenny, he simply could have asked. That's not the point! The discovery is mandatory. That is not the point. That is not the point. That is not the point! Oh my God. The discovery disclosure is mandatory. And I bet that there is a certificate of completion of discovery and this wasn't turned over. She's completely missing the point. It's not on the defense to just ask. It's on you to disclose evidence. When Kenny testified at the Gutierrez trial, he was asked directly by Bowles about his statement that Miss Zachary was Gutierrez's boss. Seth Kenny's trial testimony. Mr. Bowles. One last series of questions on the disagreement that Hannah and Sarah had. You were talking about earlier, and that was over the negligent discharge or accidental discharge, you call it, on the 60. Seth Kenny, accidental discharge, yes. Bowles. Okay, sir, do you recall telling Hannah that Sarah was her boss and not to push it? Kenny, yes. Bowles. And you were basically telling her to back off reporting anything. Shoot, I'm sorry. Geez. Sorry, Judge. Sir. He picked up this thing. Do you recall telling Hannah, I don't know what happened at that point in the trial. Do you recall telling Hannah something like to back off because she wanted to report to production? Seth. It wasn't that she wanted to report it to production because Sarah had already reported herself. That was the issue. Bowles. Okay, but in any event, you told her she should just move on. Seth Kenny. Yeah. But what does Seth Kenny say in his interview? Statement 2, Bowles was well aware of his client's experience in the film industry. Ms. Gutierrez's resume was part of the evidence in the case. If Bowles was interested in his client's experience compared to Kenny's experience, he simply could have asked him. The testimony is also completely immaterial. Statement 3, in his motion, Mr. Bowles took Mr. Kenny's statement out of context and misstated Kenny's comments in order to make them self-serving. Okay. Mr. Kenny's statement to investigators was as follows. Interviewers. What's the rattle test? Seth Kenny. It's the only way to differentiate whether or not in the moment, whether or not a round is live or is a dummy because the primers are intact. From outward appearance, it's exactly the same. The bullet is 100% real. The case for the most part is 100% real and the primer metal is 100% real, but it's just missing the active component. I think primarily it's mercury fulmite, so it's missing the mercury fulmite. Can you just say fucking gunpowder? It's missing the gunpowder, and then a BB or a piece of shot is put in there, so you pick it up and you rattle test them. It's a simple test. Again, I can't speak as to how she was trained or how Thel does it. I can say, even though I worked with Thel for a month on the set of 1883, he wasn't an on-set armorer, basically. He was a firearms trainer, and he just couldn't move around. It was too hot. A lot of people going off of the heat exhaustion, so how I do it is you test constantly. Anytime I pick up a dummy round or a round I suspect of being a dummy or something else, just instinctively rattle test it. I was trying to induce a failure like I had heard Alec Baldwin talk about. He's rattling about something else. And even though it was just me and a desk and 2-3 single action armies in the mixture of 44 to 40 and 45 long Colt dummy rounds. It's funny. I can't stop myself from rattle testing it because it's the ultimate failure is to have something like happen. Okay, Seth Kenny. It goes on quoting him saying, so when you get to the set and you're setting up with the prop cart again, that's how I do it. And I think most of the armorers on set or even the prop masters who handle guns and even experienced ones who handle blank ammo, they won't call out for an armorer. It just depends. Everybody's got their own set experiences and comfort factors, so you would rattle test them. Alec Baldwin, let's just say I'm there. It's not Sarah. You go to the cart, you open the box, you make sure it's not blanks, it's dummy rounds. And the weight of the box feels different right off the bat too. You pick it up, it feels different right off the bat. You pick it up, it feels like it's loaded. Live box. Everything that she says is out of context is him rattling about stuff. I don't think that contextualizes what's highlighted at all, but whatever. The court's going to hate all of this. Kenny's statement is consistent with all the testimony in the case, including Gutierrez's statement that rattle test is the best way to test a dummy round. It's worth noting that Mr. Kenny is not a professional prop master, nor is he a professional armorer. He is simply a vendor of firearm-related props. This is not new evidence. Kari Bose in the chat, and also Kari, I'm sorry, we are not trying to slander your name. It's got to be frustrating. For everyone in the chat who has ever had one of these cases where your name is involved, I apologize, it's not you. What the fuck did you just read? I don't know. I read Seth Kinney's rambling stream of consciousness that's typed into this freaking motion. But wasn't he presented as a professional armorer and vendor? Didn't Kari ask him all about how it should be done? Statement 4, the fact that replica guns look like real guns and both were on set of Rust was well known by Mr. Bowles as he questioned numerous witnesses about it in an attempt to demonstrate that the witness who claimed to see the guns left unattended by Gutierrez were confusing replicas for real guns. The fact that law enforcement personnel may have mistaken a replica for a real gun is immaterial to Ms. Gutierrez's defense. It's not immaterial as to impeachment, though. The fact that, okay. Statement 5, Zachary's communication with Kenny, that Gutierrez was doing great and that the director was happy, was sent to Kenny in a text message from Zachary and was in possession of the defense. All of the communications from Kenny to Zachary were contained in the cell extractions. Unless he added more to it. Statement 6, it's undisputed that Kenny was told that Gutierrez was a good armorer. The complaints he received about her prior to the shooting were unrelated to her skills as an armorer, were related to her unwillingness to assist with props. It was clear from the text exchanges between Kenny and Zachary and Gutierrez. This is not new evidence. This is not new evidence. Moreover, Bowles was afforded an opportunity to interview Kenny and ask him any questions about the text communications, but he could have prepped that with all of Kenny's interviews. Statement 7, the hotline referenced in Kenny's interview was discussed in the pretrial interview of Ross Adiago and was known to the defense as of the date of Adiago's interview, October 31st, 2023. The, quote, hotline is a number set up by the union to receive complaints about safety issues. And then it goes on to explain the interview of Ross Adiago with Mr. Bouillon, which I'm skipping. Statement number 9, Mr. Kenny made this statement during his pretrial interview on July 11th, 2023. This is not new evidence. But is it impeachment? And then it goes through the Seth Kenny pretrial interview, Seth Kenny, and it was at the time where I pulled them out, sorted them, and put them into white boxes, small white boxes, without any labeling at all. They were exactly 325 of Thell's reloads. Kari. And after you presumably used some of those live rounds at the training camp, did any of those live rounds come back to New Mexico with you? Seth Kenny, at some point they did. I've never been able to identify the date. And speaking with Detective Hancock about it, I don't know when the gray bin came back into the shop. It may have been after the 21st, after the shooting, but I couldn't tell her when. Kari Morrissey, okay, and did the gray bin come back into the shop with you? You brought it back. And this all happened in Baldwin's hearing too. Statement 10 and 20. Bowles' theory of sabotage was fleshed out during the Gutierrez trial with numerous witnesses. He asked nearly every witness who worked on set whether the guns and ammo were in reach of all crew members when they were on the prop cart. Moreover, it's unlikely that the statements of Mr. Kinney related to sabotage on set would have been admissible. It doesn't matter. He would have had to have the basis for his knowledge for his statement to be admissible. He could have been impeached on it. Statement 11. Mr. Kinney's statement that Mr. Halls and Mr. Baldwin were a, quote, boys club is his own speculation and lacks foundation for admissible evidence. Kinney was never on the set of Rust and never met Halls or Baldwin and never witnessed either of them interact with Gutierrez. Statements 12 and 13 are regarding the hotline. Statement 14 are regarding Sarah Zachary's accidental discharges. She says that's also contained in the text messages between everybody. Statement 15 and 16 are Kinney's statements that imply that Gutierrez lacked the experience necessary to properly perform her job duties as armorer on the set of Rust. This issue was well known and explored by defense during trial. Moreover, Kinney's statement has been taken out of context by Mr. Bowles. Mr. Kinney's statement to investigators was as follows. Are we going to have to read more of Kinney's ramblings? Seth Kinney. Armorer should have been the armorer. The AD should have been the AD, and Alec Baldwin should have done what he was supposed to do, right? And that more than anything is, if you've got a 24-year-old armorer, how are you not just making sure she's got every ounce of support that you can muster for her? Yeah, I mean, she's got the experience. She's got the resume for her. She's got the history. I mean, honestly, it's kind of funny. She had more time on Westerns than I had when we started 1883. I don't even know if I'd been on a Western. The fundamentals are the same. Yeah, and that's her dad. I mean, Thel Reed is a legend dad. So yeah, but I don't know. I think maybe it's just stopped being fun for her or something. I don't know. Was she swimming for bottom? You guys are, I mean, it's just nothing really obvious to me, like, quote, oh yeah, you should have known. I kind of beat myself up there for a little while, but Sarah ends up being collateral damage where I'm like, get rid of her. Dude, just do yourself a favor and get rid of her. And I've got this text exchange where I even say, quote, find another props person and we'll see if I can get you an adult armorer because I told Hannah she's a good Christian girl, da-da-da-da-da-da-da, engaged to her high school sweetheart. Hannah proceeds to call her a cunt 3 times. And sorry, YouTube. And in a week and a half, to the point where I text Thel, like, dude, you've got to talk to her. I mean, it's not my place. You're her dad. But you know what I'm trying to say here? She's going to get bumped out of the industry. You don't get fired. The phone never rings again. Oh my God. What is happening? Oh my God. Oh my God. Oh my God. Seth, I don't know if we needed any more of the context or not, but I can't believe that's all of what was quoted in the motion. Okay. Given that Miss Gutierrez's lack of experience and lack of support in her role as prop assistant and armorer was of importance to the defense, if Mr. Bowles wanted Mr. Kinney's opinion as to whether Miss Gutierrez would have had more support, he could have asked him during his pretrial interview. We're all missing the point. We're all missing the point. It's missing the point. Yes, Bowles could have asked him, but you had an interview that wasn't turned over. Freaking Seth Kinney. However, Mr. Kinney was unaware exactly what support Miss Gutierrez had or did not have, given that he was never on the set of Rust. Moreover, Mr. Kinney is discussing text conversations that the defense has been in possession of since March 2023. Mr. Kinney's statement about finding an adult armorer and his opinion that Miss Zachary should fire Gutierrez is all clearly stated in the text messages. It should have been turned over. Statement 18, the fact that Gutierrez was being pushed around by the AD and Baldwin was discussed during Gutierrez's interviews with law enforcement. Well, Bowles was there for that. and was evident from the Rust production videos. Its information was not new and was also hearsay because Kinney was never on the set of Rust. Oh God, we've got another one of Kinney's statements. Sweet Jesus. I don't want to. No. They're saying this information was not new. Mr. Baldwin was described as a difficult man by Miss Zachary and crazy by Gutierrez in their text exchanges that the defense had in their possession. Mr. Kinney's statement to investigators was as follows. Is there inexperience or the fact that she got pushed? Is there inexperience or the fact that she got punched down on? I think the AD and by Alec Baldwin got pushed around because she came out strong. She did. She was not going to let the stunt guy who wanted to shoot a blank, bring his own guns and shoot blanks to create a special effect of lots of dust and like that, and which was totally out of the norm completely. There was just something going on with this show. That's what the stunt coordinator thought he was going to do. Nuh-uh, doesn't happen. Stunt coordinator does not bring his own gun. And where is he going to get the blanks from? Horseman doesn't say load up full blanks in this thing. So she's getting hit on all sides, right? So me trying to tell her and Thel, dude, if she gets away with this, if she's not held accountable, if she knows that she's picked up that ammo up in Colorado Springs in Livingston, where's the rest of the sentence? That's not the end of it. There's a comma. Okay. Statement 19. Oh, there's more. Mr. Kinney's statement to investigator that the props department needs every ounce of support and production provided that support. That's consistent with the statements of Gabrielle Pickle and Roe Walters that production did provide additional support. Mr. Kinney's statements to investigator was as follows. Seth Kinney. Oh, yeah. I used to see text messages just like, hey, nobody would argue again. A 24-year-old new to the industry needs help. There's no doubt about it. Both of them do. I even put that in a message to producers, time short, da-da-da-da-da. Props department needs every ounce of support. Fair warning. Yeah, I'm a vendor, but I'm going to light you guys up if I don't give them the support they need. They did. Honestly, they did. Well, you're not just a vendor, though. Everyone listed him as the armorer supervisor. So him saying he's just a vendor kind of conflicts with him being listed as the armorer supervisor. None of the statements that the defense relies upon for the request for new trial satisfy the legal requirements of newly discovered evidence needed for the motion for new trial to be granted. Mr. Kinney's statements are a reiteration of his previous statements and text messages that could have been in the defense, that have been in the defense possession since the inception of the case. Oh my God. Oh, I'm just so incredibly uncomfortable because there is just so much more here. The civil cases are going to be real interesting as they continue to go on. This is wild. Undisclosed August 31st Hague report. Defense counsel has asserted that he was provided one of 3 reports by Mr. Hague. Defense counsel is either intentionally misleading the court or simply has not done his homework. The audacity.
Bruh.
Oh my God. Defense counsel is either intentionally misleading the court or simply has not done his homework with regard to his allegations against the state. Mr. Hague produced 3 reports. The first was issued August 2nd, 23, and was provided to defense. The second report was produced August 31st, 23, and undersigned counsel believed she had forwarded the report to defense counsel, but realized during the pretrial work on Baldwin's case, she inadvertently failed to disclose the report. So it wasn't turned over? It's a long way of saying it wasn't turned over. The third report was produced on October 5th and was disclosed to defense counsel and also uploaded to the discovery server for Gutierrez. The state concedes it failed to disclose the August 31st report, but disclosed the August 5th report the same day the state received it. The only report produced by Haig that was not disclosed was the August 31st report. So now we have an interview and a report that weren't turned over till after Hannah's trial. No. Noir KD in the chat said the call is coming from inside the house. Yep. Oh. Angel in the chat said, what the hell? I almost spit out my ice cream. Angel, I'm temporarily on a pause of ice cream due to a recent reading in my life, but don't spit out your ice cream. But yes, what the fuck? What the fuck? Mr. Bowles was acutely aware of Baldwin's claim that the gun... Wait, I need to back up. I skipped something because I am so flabbergasted that the prosecution's like, he had the other two reports. What's the issue? Ma'am. Your Honor, what? 2 out of 3 ain't bad. No, that's not how disclosures work, though. Oh my God. Oh my God. Oh my God. Oh my God. The only report produced by Mr. Haig that was not disclosed was the August 31st report, a report discussing the tool marks on top of the sear. The findings in this report are not exculpatory and do not result in a new trial for Gutierrez. Bowles was acutely aware of Baldwin's claim that the gun discharged absent a trigger pull and was acutely aware of Baldwin's counsel's absurd assertion. Ma'am. absurd assertion that the gun was modified by someone and the unproven modification resulted in the gun going off by itself. I'm going to go off by myself in a minute. It is worth noting that the most likely person who could have modified the gun was Miss Gutierrez. In State's Exhibit 4, Mr. Bowles verbally attacked undersigned counsel for dismissing the case against Baldwin. I mean, it wasn't that strongly worded. These counsel have said meaner things about each other in other reports. This wasn't that. This wasn't that. Bowles stated, when the sear wear and tear in the newest report, not sure what Bowles is referring to, isn't remotely evidence of modification or anything to do with trigger function or functionality of the weapon. You have videos showing the gun worked properly, cocked and fired on set. The FBI said the gun functioned properly. We read all this in the last motion. Baldwin had to have pulled the trigger, and you know it. If the sear, Bowles is likely referring to the hammer, not the sear. If the sear notches were filed down, it wouldn't have cocked. That is talking about the cock notches. It's important to note that Gutierrez hired her own expert, Mr. Kooky, I think is how we have to pronounce that. Koucky? Kooky? 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 Okay. Frank. The nice man who... This is coming up again. The nice man who pointed the gun at the bench during his testimony in Miss Gutierrez's trial. She really liked that line in the last motion, didn't she? We're just putting it in this one too. Just putting it in again. The nice man who pointed the gun at the bench during his testimony in Gutierrez's trial. As the court can see from State's Exhibit 5, undersigned counsel offered to have the gun made available for Mr. Kooky's inspection, the nice fucking Frank's inspection, and testing. And Mr. Bowles never took steps to have the gun tested or examined by Frank. The photo of the previously explained, now explained unusual tool marks on the working surface of the sear was in the possession of Bowles, and it was his duty to provide those photos to Frank for his review as the defense expert. The tool marks referenced in the August 31st report were clearly depicted in the photos that were in possession of the defense long before Gutierrez's trial. But we have multiple things that were turned over after Gutierrez's trial, including this. We've already read through this. I'm not reading it again. But the August 31st clarifies. Hagg's report simply noted the unusual tool marks, and he continued to opine that the gun worked properly and did not malfunction of its own volition. I also don't think the not turning over the report is a problem. But as to this weapon expert, I don't know if this would have been helpful to Hannah either, because if the gun's not in proper working order, that's still on her failing to do her job. Much more impactful for Baldwin, but for Hannah, it's another explanation of her not doing her job because the guns and the ammo were under her purview. The stuff with Seth Kinney, I need to see the whole interview, but it's not as easy for me to say that the Seth Kinney stuff doesn't help Hannah. The Hagg report doesn't help Hannah. It should have been turned over. It shouldn't have been turned over late. There are issues here, but the Seth Kinney stuff, I have a lot of questions about. The Hagg report, it's still Hannah not doing her job. I don't think it changes the result of the jury finding at all. And I don't think the Hagg report changes it. And the Teskey rounds the defense had in their possession. The Kinney stuff is a problem. The Kinney stuff is, well, we'll see what the court thinks. The Kinney stuff is a problem. The pattern of not turning over discovery, also a problem. So let's see. We went through all the Hagg reports. This was all in the last motion, even though she's like, I'm not going to argue the motion. And then she argued the motion. And here's Kari making the same point I think that I just made. Gutierrez was charged and convicted of using a firearm in a negligent manner and or loading live ammunition into a real prop gun and failing to perform an adequate safety check of the ammo required. Hagg has consistently opined that the gun was working properly at the time of the shooting of Miss Hutchins, and the undisclosed report is no exception. If the gun was working properly, as Hagg testified to, then there is no causation issue related to the tool marks on the top of the sear, other than the obvious causation issue put forth by Gutierrez's defense attorneys that Baldwin pointing the gun at the person, cocking it, and pulling the trigger was the intervening event. Even if we assume, and I don't think Bowles argued that very well, even if we assume that the Hagg report stands for the notion that the gun fired by itself or malfunction, it does not change the fact and circumstances surrounding Gutierrez, right? Because it's her job to make sure it works properly. I don't disagree with that point. Hagg did not perjure himself during his testimony at the Gutierrez trial, and underside counsel did not suborn perjury. Well, the court, the court has strong words in their ruling about that, but it's not relating to this testimony. Do you think Bowles will bring it up? Chat. Do you think Bowles will bring up that the court said Kari elicited false testimony in the Baldwin trial? It wasn't this testimony, but do you think it comes up in his reply? Because he still gets to respond to this. So, let's see. Suppression of additional material. In this motion, Bowles acknowledges that asserts that his client should have received a new trial due to email communications between Carpenter and the former prosecutors and Hagg and the current prosecutors. Bowles seems to assert that the undisclosed emails warrant a new trial. He makes absolutely no effort to explain how the unremarkable emails fulfill and meet the legal requirements for new trial. As such, undersigned counsel will end her analysis here and wait for supplemental briefing from the defendant. Nah. She's like, if he doesn't do his assignment, I can't do mine. Argument. As outlined above, meeting the following three requirements establishes a Brady violation. The evidence at issue must be favorable to the accused, either because it is exculpatory or impeaching. And that's why she's arguing so much that this evidence is neither exculpatory nor impeaching. I think the state is correct with regard to the Teskey ammunition. I think they have a strong argument with regard to their expert. I don't have enough information with regard to Seth Kinney. That the evidence was suppressed by the state, ding, 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 and that prejudice must have ensued. and they're going to argue the layers of prejudice. I need more information about Seth Kinney. While this is not the law that controls whether a defendant is granted a new trial, the state will address it briefly because it's argued in the defense motion. There are Brady violations. Well, I have questions about the exculpatory or impeaching. There is material that was not turned over. She's arguing it's not Brady because it's not exculpatory or impeaching. We'll see. She also argued that the court's wrong about the Baldwin case, so there's that. She said there is nothing about undersigned counsel's testimony with regard to Ms. Johnson's departure from the prosecution team that is relevant to Gutierrez's motion. There's nothing relevant about the statement with regard to the paralegal. There's nothing relevant about the doc report. I mean, it's a pattern. She goes on to say, all testimony provided by undersigned counsel with regard to Bowles' lack of interest in the Teskey ammo is based entirely on Teskey's own statements during his brief encounter with law enforcement, March 6, 2024. The undisclosed interview of Mr. Kinney is not exculpatory or impeaching, and its suppression did not result in prejudice to Gutierrez for all of the reasons outlined above. She's saying that the statements to investigators were cumulative, were mirrored by text messages, and were disclosed to the defense, and Kinney's statements to law enforcement in his pretrial interview by defense. The undisclosed report is not exculpatory or impeaching. They go on to say the state agrees generally with the defendant's recitation of the law regarding their disclosure obligations. The question for this court at this juncture is not controlled by 5-501, but rather by the 6 factors the court is required to consider determining whether a defendant should be granted a new trial. And the prosecution is saying those 6 factors are as follows. 1, probably change the result if a new trial is granted. And that is going to be a hurdle for the defendant. Was discovered after trial. Ding, ding. Could not have been discovered before the trial by the exercise of due diligence. They asked, is material. She's trying to argue in this that a lot of it's not material or is not merely cumulative. And the prosecution was trying to illuminate in her motion that it is cumulative, is not merely impeaching or contradictory. Here's the question. Does the items that we're discussing change the result if a new trial is granted as to Hannah? I think that's the biggest question here. So, you guys let me know. What do you think? Should we put up a poll? Maybe I should just put up a poll. Let's put up a poll and see what you guys think. Because that's separate and apart from like, why the fuck is this happening? That first prong is, does everything we've discussed change or probably change the verdict if there is a new trial? Let's see. I'm putting up a poll. Do the items covered by defense motion change the outcome at a new trial? That's the biggest question here. I'm going to go yes, no, and then I'm going to add need more info. All right. At this point, I have big questions about that first prong as to Hannah, because at the end of the day, she did not rattle all of the bullets. And I still think the strongest evidence against Hannah in her trial was her statements to law enforcement. And none of this stuff changes her statements to law enforcement. Am I horrified about how much was turned over after trial? Yep. But does it change the strongest evidence against her, which is her statements? I don't know that it does. And that's the issue. The prosecution said this analysis only applies to the undisclosed interview by Seth Kinney and the undisclosed report from Lucian Haig, the state concedes that the second prong of the 6-prong test has been met, as both the interview and report were discovered after the trial. The Kinney interview is what I am most interested in. I don't think the Lucian Haig stuff changes. Would the interview likely change the jury's guilty verdict if a new trial were granted? And the prosecution's arguing there's no indication that the existence of the interview would change the result if a new trial were granted. I think if I were the court, I'd want to see the whole interview. And the problem for Hannah Gutierrez, even though I'm not a fan of Seth Kinney, which is where my brain is buffering, the problem for Hannah Gutierrez is even if Seth Kinney were up to fuckery, and this is just, even if that interview shows that there's something more there, if Hannah does her job, she catches the issue. So if Seth Kinney, and this is all, I'm not saying this happened in any way. We are just arguendoing down this chain of thought. Arguendo down the road with me. If it is as the court presented it in their ruling, that Seth Kinney could have taken mixed rounds from Thel Reed back to PDQ, Seth Kinney could have provided those mixed rounds to Sarah Zachary, and Sarah Zachary could have taken those rounds on set. If, for the sake of argument, that happened, does it change the result as Hannah for her trial? Or does it change the result for Hannah in her trial? Does it change that her job was to check each round before it was loaded? Does any of that circumstance change the fundamental question about her job duties, checking the ammunition and checking the gun? Because no matter where the rounds came from, it's still her duty to check them. I mean, if ammo rained from the sky, it's still her duty to check it. So I don't know if it changes the outcome. And this is a heavy standard to meet for the defense, and they know that. It must probably change the result if a new trial is granted. Does any of this change that Hannah's job was to check the rounds and she told police that she didn't check enough? If nothing reminds you that your words will be used against you, Hannah's interview is Hannah's strongest evidence against Hannah, or is the state's strongest evidence against Hannah, because it doesn't change her saying, I should have checked more. So I don't know if this probably changes the result, because it doesn't change what her duty is and it doesn't change her job. But the court might find that it changes the argument of intervening factor. I don't know if they will. So you guys have a lot of good questions about why is this different for Baldwin, and I'm going to answer that when we get to the end of this. But I will answer that. Don't worry. The standard for new trial is different than the Brady standard that was at play in the Baldwin dismissal. Here, the court has to find all 6 of these things. The first one is probably change the result if she goes to trial again. Then the other things. The prosecution's probably going to argue not merely cumulative and not merely impeaching, but the hurdle is prong 1. And the prosecution's arguing that none of anything Seth Kinney says would have changed the verdict, because Gutierrez's job is still her job. She says, Mr. Kinney is simply a vendor. I think that misstates things. I think it absolutely misstates things, because he was also the armorer supervisor. He wasn't just a vendor. Any training deficiencies suffered by Gutierrez would be the fault of her trainer, Thel Reed. Well, He was the armor supervisor. So, no. The Hag report, I don't think the Hag report would have changed the outcome. It should have been disclosed. I think it's a Brady violation. I don't think it would have changed the outcome. Let's see. With regard to the defendant's arguments that she should be released pending appeal, the state hereby incorporates all arguments submitted in response to defendant's motion for release pending appeal filed May 27th and its response to the defense motion. The state is asking the court to deny the motion, and attached the emails again and the call sheet. And those, these have been disclosed in the last motion as well. So let's try to summarize that, shall we? 42 pages of the motion filed by Kari Morrissey. Well, no, inaccurate. 42 pages of opposition filed by Kari Morrissey with quite a lot of snark, a very on-the-nose statement that she disagrees with the court's ruling in the Baldwin case and still doesn't understand how the court came to that ruling, CEG, the court's scathing written order in the Baldwin case. She talks about an undisclosed Seth Kinney interview, an undisclosed expert motion, and the ammo from Troy Teskey. The ammo I don't think is super relevant to the motion for new trial. The defense had it. It was a defense witness. The defense chose not to call the witness. I don't think that comes up at all. The undisclosed Seth Kinney interview, I don't think is as easy as a question. And the undisclosed Hag report, I don't think changes things all that much. Yes, the state should have turned it over, but after trial, I don't think there is a remedy for that, because the first thing that has to be proven by the defense for the new trial motion to get granted is that it probably would change the result if there was a new trial. And I don't know if showing that somebody may have done something with the weapon changes Hannah's responsibility to do her job. That's possibly the same with the Seth Kinney interview, but without the entire interview, it's hard for me to really evaluate it. But you have to show that something in Seth Kinney's interview would change the result if Hannah gets a new trial. I think that's a very difficult standard for the defense here, because the strongest testimony to me in the entire Gutierrez prosecution were Hannah's own words in her multiple police interviews. It was her job to check the ammo. She wished she had checked more. She doesn't remember if she checked them all. She shook the box together. I don't think anything changes that testimony. And I understand that it's like, but it seems different for Baldwin. Baldwin's dismissal was a result of a Brady violation during trial, and there was no other remedy for the court. Defense for Hannah is asking for a new trial, but that comes under its own decision matrix, its own elements that include the result would have been different. Baldwin didn't have to show that this changes his trial. It was a sanction against the prosecution and police. Different than the motion for new trial. So we are dealing with different standards, with different elements under different case law in the Baldwin case and the remedy in that case versus does Hannah get a new trial? Hannah has a much more difficult argument to get a new trial than Baldwin's argument for a dismissal. Will the court do it anyway? We'll see. If the court decides that the appropriate sanction here for the prosecutor's behavior and that the result might be different because of intervening causes, we'll see. But it is a much more difficult argument for the defense to make. And I don't think the court's going to release Hannah while that decision is being made, no matter how upset the court is with Kari Morrissey. But I don't think Kari Morrissey telling the court that their decision in the Baldwin matter is flawed is going to go over well at all. No. But part of judicial temperament is being able to put that aside and look at the facts here and the law and see if the facts as they are and the law as it is warrant a new trial for Hannah Gutierrez, and they very well may not in this case. So you have lots of questions. I've got lots of questions. Let's go. But when we clip this down to quick bits, don't worry, y'all. We're going to put some of me reading that motion because some of the audacity needs to be in there because woof. All right. Oh my God. How have we been streaming for almost 4 hours? No wonder I'm hungry. All right. Let's get to some questions real quick. I told y'all there was a lot to cover today. There was so much to get to, but we need to get to your questions. I'm going to do that, and then I have got to get some food. Green-Eyed Southern Girl asked in the chat, doesn't she have the same Brady right? And Kay said, can the interview be a Brady issue? All of these things can be Brady issues, but they have to get to the motion for new trial. So the court dismissing this as a Brady remedy would be different than the court granting the motion for new trial. So they are different standards. The defense is asking for a motion for new trial. I think the defense will throw in, just dismiss it for the Brady violations because there's repeated violations here. But even under the Brady standard, it has to be material. The Teskey stuff is not a Brady violation. And they're arguing that the Kinney stuff is not a Brady violation because it was cumulative. And so it was already disclosed. And they're arguing, the prosecution's arguing that the Hague report is not a Brady violation because it's not material to Hannah. We'll see. But on the new trial, we've got to get across that hurdle of does it change things? I don't know that it does for Hannah. Bridget said, could any of this be used in the pending civil lawsuits? The facts can, but it just depends. It depends on what facts and what's known in the civil suits. For the civil suits, the more information, the better. Bridget, thank you for the 10 gifted memberships. Haley, thank you for the gifted memberships. Let's see. There are more questions. Christina, thank you. Christina said, hi, Emily. Okay, so Kari didn't want to win at all costs, but also gave Baldwin and Hannah a get out of jail free card, but also motioned for full sentence for Hannah, but also refused to dismiss the case after evidence came out compelling her. Sure, Jan. It's a lot. Trisha said, great live, belated birthday gift for me. Happy belated birthday, Trisha. Phoenix said, both of these cases have been a fever dream. Hannah Gutierrez Reed's defense sucks. Prosecutor was shady. And now this. Has anything gone right in this debacle? I think the court got the right result in Baldwin, the legally right result. It sucks for Helena's family, but I think the court got the legally right result, and it sucks. B2, we were chatting about you, B2. I was like, B2, not this B2. No, our B2. Thank you for the gifted memberships. It's good to see you in the chat. Jolene, thank you for the gifted membership. SF said SK had over a month to be able to pull all the projectiles and change the powder in the 1883 rounds, so they could have been the same as from Rust. It's a fair argument. Could have gotten rid of them. There's a lot that could have happened. There's a lot here with that. It's Dr. Jade said, sounds more like a civil motion, so contentious. These attorneys have been at each other about this. Noir said, how likely do you think the DA's office gets rid of Kari now after throwing shade at the judge's ruling? They've already paid Kari, so I think they're going to make her finish out the Hannah Gutierrez motions because they've already paid her to do this case, and they probably don't have anyone on staff that wants to. Like, if I was the DA's office at this point and my boss came to me and said, we're going to need you to go argue these cases, I'd be like, you made your bed. She can go lie in it. This is her mess. I'm not here to clean up that. Nope. You hired her as special prosecutor. You got all the taxpayer money to pay her. You've already paid her. Her bed, she lies in it. Not doing it. So no, I don't think the DA's office is going to replace her on Hannah Gutierrez's case unless they are forced to. I think they're going to let her finish it out because it keeps their office out of the line of fire a little bit. So what an absolute mess. Noelle said, Kari responds, sorry, Your Honor, there's not enough wheels on the bus. And the judge is like, those wheels on the bus go round and 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 round. Mary said, just got out of the hospital and major surgery. A success. So happy to be back. Mary, Hope, I'm glad I was a success. Heal well. Heal well. Aaron W. said she's tying bowls to the railroad tracks. I mean, Kari was so mad. So mad. So mad. Froggy Girl gifted 5 memberships. Thank you so much for the gift of memberships. Music to My Soul asked, could Erlinda sue Kari for defamation for things that Kari says in the context of ongoing litigation? No. Nope. Mary said, this is why I watch EDB. I love that she doesn't speculate. She focuses on the facts. I'm here to learn and laugh with EDB as an ace at both. Thanks for everything. You're welcome. If I'm going to speculate, I'll tell you where it is. But things that we're going to find out, like I will speculate that we'll probably see more motions from Coffeezilla. But when it comes to things that we're going to learn in court, like what's going on over the lunch break, nope. Not going to speculate. And I will always tell you when I do speculate. What an absolute mess. Tasana said, these are not the droids you're looking for. Yeah. Isn't it wild? All of this is wild. All of this is wild. Sweet and Salty said, how is Kari Morrissey still on this case? CEG, my last statements that they've already paid for her and she's got to deal with the mess that she made, right? I'm not cleaning up. Lisa said, I think the defense asked for more time in the Karen Reed case. The jury should have been less confused too fast. They might have. I haven't heard anything really conclusive about it. And I don't remember them saying it in court. They might have. And it's wild. So Marsha asked, Emily, what are the lesser included in count 2? I did a whole podcast breaking it down. It's here on the channel. So if you look under the videos on demand, not the lives, it's on there. I broke down all of it. Jay McCarthy said, I work in HR. I too love to piss people off in a pantsuit. I have green hair. And when I put on my full purple suit or pastel rainbow one, let's just say I look great in a sea of uniforms. I mean, life's too short to not be colorful. Kelly, thank you. I will take a look at that. I have gone through quite a lot. Need to know the file date, docket number, or DOB. I've got the docket number. The dates are sometimes hard, but I will take a look at that. I appreciate it. Let's see. Chloe Albert's Revenge says, I think it can be done by butt dial. That's getting the documents in Massachusetts. I should have tried. I have not tried to butt dial it yet. I'll try that. Thanks Forever or TX Forever said, yay, I got to spend my 55th birthday with EDB and my fellow law nerds. Heart and cowboy emoji. Happy 51st birthday, TX Forever. FBI Black SUV said, best advice ever. Emily, thank you so much. I hope that advice, or I think that's related to make the best decision you can at the time with the information you have. Yeah, there's not much else we can do. Or you can delay until you have more information, I suppose, and then repeat. Love DMB 4136 gifted 1 membership. Thank you. Good to see my fellow Dave friend. The Hall of Fame, Rock and Roll Hall of Fame tickets, I think go on sale Friday, the same day that we are going to be in court. Friends, I know there are more questions. I am going to try to get to them, but J. Michael, 35 months on my birthday, and hi to my kiddo, Jade. Hi, Jade. Happy birthday, Michael. I hope it is a wonderful one. Cheers to you. I'm sure the law nerds have already said happy birthday. Happy birthday. Music to My Soul said, not to belabor the point, but the Karen Reed closings, I still don't understand how they could have argued the elements in the charges when the judge hadn't read the instructions yet. They can. They just bring them up first and argue them, and you're allowed to. And they could have asked for a pre-instruct, post-instruct. There's a lot. I don't know what the judge would have done, but you have some options there. But I've argued the jury instructions when the judge instructs afterwards. And I say, essentially, you are going to hear the judge say this, but the instructions are this and the elements are this. And when I am done here, the judge is going to say this too, but these are the elements we need to talk about. Let's talk about it. Madre P said, can Helena's family bring a civil suit against Kari? She's going to be protected by immunity in her role as a prosecutor for the work that she is doing. So no, there is not much that they can do. Bar complaints, maybe. Civil lawsuit, no. We need to talk a little bit with all the law nerds that are still here about schedule. And then I've got to go. It is a busy week. I very much want to cover the Kari Richins hearing Thursday. I don't know if it will be streamed. I don't know what time I will be covering it. So, app and YouTube, I will let you know when I know what time I'll be streaming on Thursday. It's likely not going to be at our normal 11 a.m. time. It will likely be later in the day. So I will keep you posted on when I will be streaming on Thursday. If it is not streamed, I may not stream on Thursday. I'll keep you posted because Friday we are going to be in court in Massachusetts for Karen Reed. There is a new podcast episode dropping tomorrow for you, going over some of the stuff in Girardi and what's going on in Young Thug. More stuff is going on with Young Thug. It's been 2 days of hearings. We'll see if there's any resolution. If there are, it'll be in the notes for the podcast and I'll update it in our app. With that, we are on the bubble for Thursday. I'm not sure what the schedule looks like yet. Friday, we will be in court for Karen Reed. I am riveted to be in court. That'll be Friday afternoon. So put it on your calendar now. Y'all are in court on Friday. We got motions hearings in the afternoon Eastern time. So roundabouts 1 p.m. Central. That might shift a little depending on if the court shifts. And we will do that. So I will see you in court on Friday. I am very optimistic that I will see you in court on Thursday. I am dying to see these Kari Richins motions. Dying to see them. Because so much is happening in that case. She's got new defense attorneys. We have lots to catch up on over in Utah with the children's book author that is accused of poisoning her husband with fentanyl, having a lover, and Googling luxury prisons for rich people. Oh, the Kari Richins case. And, you know, in honor of Kari Richins, I'm going to have to like bleach my teeth a little bit more because she was trying to smuggle Crest White strips into the jail. So we're going to have to do that. So to round out, do the items covered by the defense motion change the outcome at a new trial? 26% of you said yes. 33% of you said no. 41% of you said need more information with over 2,000 votes. And I wonder if that's what the court is going to ask for when these motions go to hearing. We still need to see Bowles's response to Morrissey's opposition, and then the court will set a date for argument. The court does a lot of that over Zoom. So when the court has that hearing, I will let you guys know. I will absolutely do my best to cover that live if we're not in the middle of another trial. We've got lots on the docket. The fall is going to get busy. I have we've got a very busy few weeks with back to school and band and all the rest of it. So stay tuned to the app. I will keep you posted about schedule and streaming best I can. Generally, when we're not in trial, Tuesday, Thursday, 11 a.m. Central, subject to change based on court dates. So at a minimum, I'll see you Friday. I will see you around the interwebs. I'm going to catch up on some Olympics and get some lunch at 3:00. And I will see all of you soon. Thank you for being here. Thank you for being a law nerd. I love seeing you in the chat. What a wild ride. The audacity of today. Like, all day long. All day long. Oh, the court's going to be mad. I'll see you guys soon. You can stay up to date with everything I'm covering and fast notifications on our free iOS and Android app at lawnerdapp.com
or search the App Store for Law Nerd. You can also follow me around social media, and don't forget to check out my podcast, The Emily Show, with quick bits dropping every Monday, summarizing everything I do here on the live streams on Tuesday and Thursday for when you just have time for the quick bits. Thanks for being a Law Nerd.